Good morning. Court is now in session. Welcome back, Lit Lane jurors. Happy Friday to you guys. Happy Friday. Thank you for reporting for duty this morning. Don't forget, there's no night court this evening. We will meet back to Monday morning for night court. As you can tell, jurors, I left a poll for you guys. Have you voted on the community wall poll? I think last time I just peeped, the answer was no. I'm pretty sure before this court adjourns today, the yes, everyone will go vote for the next trial to be featured. Good morning, Juror M. Renee. You gonna be up in the clouds and down in the bushes? All right. All right. Thank you for coming in and being here. It's on the please tell me I put that poll on the right wall. Let me see. Living say she voted. What? Please tell me I put the poll on the right wall. Okay, yeah. Once you go refresh, Renee is there. Okay. Good morning, BA Sage. Good morning, Winter. So today is part 2 in the verdict. We still have some testimonies, but we will absolutely be getting to the verdict in the state of Georgia versus Larry Lawson. Our first real little quickie trial. That we started on yesterday. This is a case where the charges are aggravated assault, battery, and family violence. Okay. The defendant is one Larry Lawson. The state picked up the charges against him stemming from a domestic violence situation at his home with his baby mama / girlfriend / come to find out, the shooter. Okay. So the allegations are that Larry Lawson, the defendant, came home intoxicated. Once he got home, he wanted to go back out. He wanted to use his girlfriend's car. Of course, she saw how this was not going to be a great idea. That could only turn out bad. She tried her best to prevent him from going out driving drunk. He didn't like that very much. An altercation ensued. Whereas his girlfriend, Miss McCrary, alleges that he kind of pushed and shoved. She alleged that she got hit in her ear. She alleged she got hit in her lip and ended up with a busted lip. And also that during the skirmish, her 12-year-old daughter got pushed by the defendant. Once she was able to break away and they partied away from each other, he kept pursuing her in this aggressive manner. She made it to her bedroom, locked the door. Oh, okay, Renee. Okay, I see. Okay, I got you now. Good morning, Tanya. So once she was able to break free from him. She according to her, she went to her bedroom, locked the door, went ahead and took out her weapon that was properly locked up in the lockbox. He got through the locked door. She gave him a warning. He kept advancing aggressively. She shot him in the leg in an effort to try to stall him, stop him, any further violence in the household. Now, she has not faced and will not be facing any charges, it's apparent, for shooting him in the leg. They call that self-defense. Who is on trial is Larry Lawson for the domestic violence, aggravated assault, and battery. Okay. Good morning, for soldier. Welcome back. At this point in time, we have heard, I'm pretty sure the defense, I mean, not the defense, the state has rested. We heard from a couple of sisters who arrived to the scene. We heard from an EMT. We heard from a lead detective. We heard the 911 call. And everything seems pretty much on the up and up as far as I'm concerned. Please like and subscribe if you have not done so yet. And we're going to get into this because I want us to get to a verdict. So I'm pretty sure, but we shall see that the defense is about to start its case. Let's push play.
Apologize to you friends here who are here on time. And we do other things connected with the case while we're waiting, but maybe tomorrow, if there is a tomorrow, you'll show up early and have donuts for everyone. We'll see. I'll let you negotiate that with the group. Yeah.
That's right.
All right. We are going to continue with the presentation of the state's case. I told you last night when we broke that Ms. Beza forecast that she had 2 witnesses left. She's sticking with that forecast for now, and I'll ask her to call what may be her penultimate witness.
Okay, so the state is still calling. Okay, we're still doing the state. Let me put myself on mute and take care of my dog. Rock says, good morning.
Facing your raise right hand. You swear to affirm that testimony you will give the truth, the whole truth, nothing but truth, so you are. Okay. Go ahead, see. Can you state and spell your name correct?
Heather Williams, Heather. Williams, Williams.
Good morning.
Morning.
Valerie, I got the about to testify as an expert in strength.
Yes.
Welcome back.
What information and or documents did you review in this case in order to prepare for your testimony?
There was an arrest record, an incident report, and 911 calls.
Now, where do you currently work?
I work at the Refuge Sexual Assault Center in Vidalia, Georgia.
What are some of your duties and responsibilities there?
I'm the coordinator of the program, so I make sure that all the patients are well taken care of. The advocates and the nurses that are working for me are well trained and know how to take care of the patients, as well as do some of the sexual assault and forensic non-fatal strangulation exams myself.
How long have you held this position?
I've been there since January of 19.
Where did you work before?
I taught nursing.
Where?
At Southeastern Technical College in Vidalia.
And how long did you do that for?
About 10 years.
And then prior to that, did you have any jobs?
Hospice nurse.
And what did you do as a hospice nurse?
I was a case manager, so I was assigned a case of patients to help them through their final days.
Do you have any license?
I do. I have an RN license.
What does RN stand for?
Registered nurse.
How about any certifications?
Yes, I'm certified as what's called a SANE-A. That's SANE-A. That's an international certification. It stands for Sexual Assault Nurse Examiner, and the A stands for Adult and Adolescent. So I don't take care of pediatric or child cases. We do adults and adolescents. I also have a certification that's an IVSE-C. That's Interpersonal Violence Strangulation Examination Certified.
And what does that?
It means that I passed the certification test to be able to identify and care for the strangulation patient who is, it was a non-fatal case. So the patients that I take care of are alive.
Now, you're part of any professional organizations?
Yes, I'm a part of the IAFN, which is the International Association of Forensic Nurses, and the AFN, which is the Academy of Forensic Nurses.
Now, you've mentioned in your experience that you have examined patients who have reported to be strangled, correct?
Correct.
In your experience as an RN and working period, approximately how many patients have you personally examined or you supervised the examination?
Personally done a non-fatal strangulation myself that is not tied to a sexual assault. It's high 80s, 88, 89. However, some of these sexual assaults that I have performed, the exams that I performed also have a strangulation component in it, and that would be high 30s.
Now, what is a strangulation exam?
A strangulation exam, when you come into my center, is a very specific head to toe. First, we start with a discussion with the patient. We get their medical background, their medical history, and then we start to discuss with them what happened. We let them tell us what happened during the case or during the assault to let us know how that guides our physical exam once we get into the exam room. What are some specific areas that we need to pay attention to that could have been injured, whether we actually see anything or not. So we take them into the exam room after the discussion, and we do a head to toe, basic head to toe, everything from the top of their head to the bottom of their toes, that we either see an injury, the patient complains of pain, or they state something happened to that area of the body we hyper focus on. We take a series of at least 3 photos of every identified injury area, so that we can make sure that we get a good look at it. And then possibly using other things such as alternate light sources to help us identify other injuries that we can't quite see with our naked eye.
Have you taken any strangulation-focused trainings?
Yes, I have.
Please explain to the jury what type.
There is an organization that falls under something called the Alliance for Hope International. It is called the Training Institute on Strangulation Prevention, and that's out of California. I've attended their 4-day advanced course training on strangulation. Once you complete that, you are eligible to attend their 2-day Master's Summit. I have completed that, as well as attended in Texas their 2-day Expert Witness course. And then they offer webinars and trainings virtual all the time that I'm always attending.
And you mentioned previously, but can you please further explain to the jury, have you done any presentations on strangulation?
Yes, I have presented on this topic at the local level to our local law enforcement, GBI, our medical professionals in the local area that I serve, as well as through GIPSTIC for regional, which is the Georgia Public Safety Training Center in Forsyth. I've also trained at the national level at conferences such as the EVAWI, which is End Violence Against Women International, on this topic, as well as a Georgia-based annual conference, which is the Georgia Coalition Against Domestic Violence.
Have you previously testified as an expert in strangulation?
Yes, I have.
Do you know approximately how many times?
4 times.
And at this time, the state would move to deem Ms. Heather Williams an expert in strangulation.
Ms. Feely, would you like to voir dire or examine Ms. Williams on this topic? Okay. And ladies and gentlemen, so you know, Ms. Beza is not done. She's going to have more questions, I suspect, for Ms. Williams. But when we get to this question of do I qualify Ms. Williams as an expert, the other side is entitled to ask questions about qualifications as well, so that I've heard not just the questions the state might want to ask, but that the other side might want to ask about Ms. Williams' qualifications. So I'll hear from Ms. Feely, rule on the request to qualify, and then Ms. Beza will be back up.
So I have your resume here. I see that you have a bachelor's in nursing, is that right?
Correct.
And you have a graduate certificate in nursing education.
I have my Master's of Science in Nursing, and the focus of that was in education.
So you do not have a PhD, is that right?
I am not.
And you do not have an MD as well?
No.
We don't have any background about what organizations you got your certifications from, right?
I haven't provided any information about my certifications and how I obtained them.
And you just testified that you have testified in a trial 4 times. I have what must be an older copy of your resume. I have that you once testified in Fulton County as an expert witness, is that right?
Correct.
And you once testified, not in a trial, but in a sentencing hearing.
Correct.
Then I have that you consulted on a strangulation case. Can you tell me what was the other times you testified?
They were in my local area. One was in Emmanuel County and one was in Toombs County.
It was at trials?
Yes.
That's all I have any questions on.
Okay. Do you have, other than having fleshed out this situation, do you have any objection to having Ms. Williams qualified for purposes of this trial as an expert in strangulation?
Based on the demonstratives that we received from the state, it does appear that she will be testifying about anatomical, medical situations that it's our position she's not qualified to testify on.
Okay. I'm going to qualify Ms.
Welcome
Williams
back,
as an
Statue
expert
friend.
in the field of strangulation, and the concerns that you all in the jury have heard from Ms. Feely would go to the weight of the testimony as opposed to its admissibility. So for the purposes of this trial, you are an expert in the field of strangulation. Ms. Beza.
They
So
tried
Can you please define choking and strangulation in any difference?
Sure. So a common misconception is that when anybody who is, they say they're choked out, and they use that word when they're trying to explain some type of assault where something was put on their neck. The true meaning of the word choke or choking is when you take a bite of something that's too big, you try to swallow it, you can't, it gets stuck. Choking is an internal, inside the body cause. It's an airway cause inside the body. That is choking. Strangulation is an external, outside of the body cause. And strangulation, it can impede not only the patient's ability to breathe, like choking, because pressure is being applied on the outside of the body, but it also concerns us that there may be cardiovascular issues with blood getting to and from the brain.
Can you please describe what different methods there are of strangulation?
So there are 3 different manners of strangulation. The first one is manual. A lot of times when we say manual, we think hands. Manual means any part of the body. So it could be hands. It could also be the crook of the arm. Someone comes up behind and puts someone in a rear chokehold. That could be considered strangulation. Any other part of the body, the forearm, the knee, the lower leg, any part of the body that's putting pressure against the neck, that is manual. Ligatures are anything else. It could be a wire, it could be a telephone cord, it could be an article of clothing or a scarf. And then we have hanging. Hanging is strangulation that occurs based on the weight of that patient's body strangling them. So there has been something placed around the neck, and then they are hanging where their feet are no longer touching the ground, and the weight of their body causes the compression around the neck, causing the strangulation.
Now, I'm going to ask you to define asphyxia and hysphyxia, but we're looking at a demonstrative help aid in that explanation.
Sure.
I'm looking in front of you at State Exhibit 55.
Mhm.
Would this demonstrative help aid your testimony in explaining asphyxia and hysphyxia?
Hypoxia.
Hypoxia.
Yes.
I cannot pronounce these words.
Sure, we can use this.
Your Honor, at this time, the state moves State's Exhibit 55 into evidence as a demonstrative exhibit.
Ms. Feely, any objection to States
Welcome back,
55
Ken.
as a demonstrative? It's admitted.
Publishing States 55 at this time. Can you please explain asphyxia and hypoxia?
Hypoxia is simply the condition of having low oxygen in your blood. And it could be from a number of different reasons. Asphyxia is the body's inability to either bring in oxygen into the body, or the body's inability to deliver oxygen that has gotten into the body to the different body tissues. So specifically in strangulation, we're referring to the body's inability to get that oxygen-rich blood to the brain. So asphyxia, we can't either bring it in because maybe our lungs can't expand. There's pressure on our lungs and we can't take that nice deep breath to bring that oxygen in. Perhaps there's pressure on the throat that they cannot, and the airway is smaller, more narrow. They feel like they're sometimes breathing through a straw and they can't bring in enough air to get enough oxygen. Or if they're breathing and they're doing fine with bringing it in, it's not getting to where it needs to because there's some type of blockage, not getting it to the tissues it needs.
Now, using State's Exhibit 55, in your expert opinion, if someone was being strangled with a forearm directly to the center of their neck, so person is on top of putting pressure on the center of the victim's neck with their forearm, kind of how would that affect this exhibit, this neck?
So if you see in the middle where it says trachea and larynx, that is the dead center of your throat. That's your airway. And if there is pressure being put directly on your airway, that is going to lessen the amount of oxygen that you can bring into your lungs when you try to take a good deep breath. So that can cause asphyxia because we cannot bring enough oxygen into the body. If there's anything that is compressed on the side of the neck, that's where we see the red lines. Those are our carotid arteries. Those bring oxygen-rich blood to the brain. And if at any time the sides of the neck are compressed, those can be impacted. But specifically talking and concern for the front is that we're making that airway smaller due to the amount of pressure that's being applied.
And in your expert opinion, if there's pressure applied to the trachea or that front part of the neck, would that person, obviously it depends on the amount of pressure, et cetera, but could that person feel like they were about to pass out?
Yes.
Now let's talk about or move towards the external signs of strangulation. First, I would ask you, where would you find, if there were, visible signs of strangulation?
That's a very broad question. We look, of course, anywhere on the neck, front, sides, back. We look under the jaw. We look down in the collarbone area. We look behind the ears. We're not always privy to having marks anywhere, but we do examine the entire neck, under the jaw, behind the ears.
And for the juror's knowledge, what is petechiae?
Petechiae, petechiae are little tiny red pinpoint dots that appear on the skin, and they occur when there's a buildup of pressure in the vascular system. So in the body, in our neck area, big fat carotid arteries that carry that good oxygen blood to the brain. It drops it off, brain stays alive, but that blood needs more oxygen,
side,
so it drains back out through the jugular veins, again, which you have on both sides of your neck. If the jugular veins, which sit a little bit closer to the skin, if they are blocked, but the carotid arteries stay open, then blood is going up to the brain, but it can't get out. It's kind of like a kink in a water hose. And behind that kink, the water's still coming and the pressure's building. So behind that kink, the blood is still coming, but the pressure is building. Well, there's not infinite amount of space in the brain that it can go. So when it gets to the tiniest little parts called capillaries and that pressure's too much, they pop, they rupture. And then they show themselves on the skin, perhaps on the roof of the mouth. We can see them in the ear. You can see them literally the whole body. They can show up anywhere. That's what we see, is that buildup of pressure, and those petechiae are the evidence that we see from the blood vessels popping from the buildup.
Now, in the manner of strangulation that I described before, kind of forearm being pressed against the middle of the neck, in your expert opinion, could that cause the person being strangled to have pain to her neck in the following days?
Yes, absolutely.
How about dry mouth or coughing?
Yes.
Why is that?
Those are common symptoms, actually. Anytime the neck is very delicate. The muscles in the neck are very delicate. And oftentimes when a patient has been strangled, it's almost, if you've ever been in a car accident, that day you're like, I'm fine, I'm good. And then you wake up the next morning and you're like, wow, I'm hurting all over. None of this happened yesterday. It's the same concept, because you have this trauma response, your adrenaline is rushing, you're in a life-saving, life or death moment, and you don't realize what hurts actually at the very moment. Sometimes it takes a little bit of time later, and then you start noticing things like, it hurts to swallow today. It's a little difficult to swallow like solid food. Or, gosh, when I turn my neck certain ways, it's kind of sore. Or I'm having trouble sleeping. I can't get comfortable on my neck to sleep. And those are all very common symptoms after any type of strangulation.
And do you sometimes find, in your expert opinion, that there is no outward injury that you can see with the naked eye after a person's strangled?
Absolutely.
Please explain to the jury about why and about that.
If I don't see anything, I am not upset. I'm not overly concerned. If I do see markings, I'm not upset or overly concerned. The presence or lack thereof of marks on the outside of the neck does not mean anything, does not speak anything to the severity of the strangulation or if a strangulation occurred at all. We have studies that show us 50% of the time after a strangulation, there will be no marks on the neck. Of the remaining 50%, 35% of the time, there might be marks that are slight, but maybe visible to the naked eye, but they don't photograph or video well. Because, you know, when what we see with the naked eye is better than what we can photograph most of the time. So the 35%, they might be there really faint, don't really show up. That leaves 15% of the time that a patient is actually strangled. Are you going to have ligature marks, pattern marks, scratch marks, anything, bruising, petechiae that you can equate to the strangulation? So if they show up for their exam and they're seeing me and I don't notice any marks, that doesn't tell me that nothing happened.
No further questions for this witness. Thank you.
Ms. Feely, do you have questions for Ms. Williams?
That turned out interesting.
I want to start with, you said something very interesting that I wanted to follow up with you about. You said unequivocally that the lack of any physical evidence speaks nothing to the severity of the strangulation. Is that your testimony?
Yes, it is.
Now, if it is a fatal strangulation,
Yes.
the medical examiner will be able to tell that. Is that right?
If it is a fatal strangulation, we have studies that showed up to 40% of strangulation homicides have zero external marks at the time of autopsy.
When they have the autopsy.
When they cut them open, yes.
Well, let Ms. Feely finish her question and then you're free to answer it.
So tell the jury about what would be seen internally.
On autopsy, I'm not a pathologist.
Oh, okay, so you're not an expert in that, okay? So you also said that 50% of people claiming to have been strangled don't have any outward.
That is correct.
So if I had been strangled an hour and a half ago, this is what I would look like, most likely.
It's very possible.
And what about if I had been strangled yesterday? This would be what I would look like?
It's very possible. Everyone bruises differently.
Sure. So if someone was strangled and the next day or 2 days later, there could come bruising at that point from the healing process, right?
It's possible.
Now, you also mentioned that when you do exams, you take at least 3 photographs of each injured area, right?
Correct.
And you make sure that you use optimal light settings.
Correct.
And so just to be clear, that anatomical drawing that you were using, and you were telling the jury all about that, you can't tell me anything about what internal findings would be from somebody who died of strangulation.
Objection, Your Honor. This witness is not a pathologist. She doesn't do autopsies. She's an expert in strangulation, not pathology.
Okay, that may be the point that Ms. Feely is making. So would you repeat your question and then Ms. Williams, you should answer it.
As an expert in strangulation, you are telling the jury that you are not familiar with what the findings would be from somebody who died of strangulation.
I am trained on the anatomy and pathophysiology of strangulation in non-fatal cases.
So that's it.
I do not do autopsies.
And in all of these trainings that you've done in strangulation, you've never had any training about what findings there would be in fatal strangulation.
My training is on the non-fatal strangulation patient.
Defense gonna have to come up
In
with
this
something better.
case, you did not look at any medical records, is that right?
I did not have medical records.
Didn't look at any imaging or anything like that?
I did not have imaging.
You did not examine any photographs of the alleged strangulation victim?
I did not.
You didn't speak with the responding officer?
I did not.
You didn't speak with Ms. McCrary?
I did not.
You didn't review the police report?
I reviewed, I did review it, and I believe it was titled an incident report and a arrest report.
Have you reviewed a record of what someone else told a police officer, is that right?
Statements were in those reports.
But those statements were not made to you?
No.
Now, you mentioned your local area is Vidalia, so you came to Atlanta for this trial, is that right?
Yes.
You're being paid by the Fulton County District Attorney's Office, right?
I'm currently not being paid by the district attorney's office.
So you voluntarily just came up here for trial?
This was considered part of my job for today.
And in your 4 times testifying as an expert witness, those were all for district attorney's offices, right?
Yes,
You've never once testified for a defense attorney?
I've not been asked.
Thank you for the $9.99 super sticker. We on the go today. We're trying to reach 3 super stickers.
And what is your full-time
Thank you in
position
advance, and
again?
thank you, Libby.
I'm the coordinator at the Sexual Assault Center.
And you have never examined someone and determined that they were not strangled, right?
That's not up to me to decide.
So no.
It is not up to me to decide whether or not the strangulation occurred.
So I guess my question is, in all of the people you've examined, it's your testimony that they were all victims of strangulation?
I believe my patients.
Ms. Beza, any
That was
redirect?
good.
Yes, Your Honor. In talking about, we're cross-examined on external injuries and internal injuries. To clarify with strangulation, what are some different factors that may determine whether or not a person would have external injuries after a strangulation?
The amount of time that the pressure was held on the neck, the amount of pressure that was held on the neck, the item. So was it something small or something large, something like a wire versus hands? That can make a difference as to whether or not you see anything. The patient's underlying health conditions, there are certain health conditions that make people more prone to bleed. Are they on blood thinners that may make them bleed easier? Certain cancers can make you bleed easier. There are a lot of different factors go into whether or not you're going to see something.
Is skin color factor as well, whether
The darker the skin, the more difficult it is to identify bruises.
No further questions.
Ms. Feely, any recross?
No.
All right. Jurors, any questions for Ms. Williams? Thank you.
So why they do that? So we see Winters in my comments. I know a lot of you guys are at work, but if you're not at work and you can get to your key and you're able to chat, what do y'all think about this testimony? Did it help more for the defense, or did it help more? Did it help the state more or the defense?
Lack of oxygen occur just from some.
My bad. I forget this judge do side. He asks questions himself.
Or the abdominal area.
I forgot.
If it's the
Oh Lord, here I go. Oh Lord. All right, Demetra. All right, Judge did it.
Ms.
I have
Beza?
to remember to
They
give
call
him
Rosa
time to
James.
ask a question. Oh Lord. I'm just gonna leave it here. My bad. My bad. Oh, and I was talking over them speaking. We on a I can't get the super sticker goal to work, but we are there. I go, but we are on a challenge today for 3 super stickers. Lemon started us out with a $9.99. Boom, Sassy, thank you for helping me reach my goal with that $1.99 super sticker. Everything helps and help build the channel. Thank you guys so much. One more
Rosa
to go.
James, ROSA JAMES.
Good morning.
Good morning.
Where are you currently employed?
I am currently employed with my own contract company, Zinnia's Place.
Can you please tell the jury what Zinnia's Place is? Zinnia's Place is.
Can you
Zinnia,
spell it?
yes, SANIYAH Place. Zinnia's Place is my contract company.
Welcome
I
back. Donna.
use that company to do speaking engagements, training, research behind intimate partner violence and gender-based violence, and also expert testimony.
And how long have you had that?
I started the company in March of 2023.
Where did you work before?
Fulton County District Attorney's Office.
As what?
I was the domestic violence trainer. I was the senior advocate for victim witness, and I also did expert testimony.
And how long were you at the Fulton County District Attorney's Office?
I started at the Fulton County District Attorney's Office in July of 2019.
Now, Ms. James, do we know each other through your work at the Fulton County DA's office?
Yes,
And have we worked on other cases together?
yes.
However, in relation to this case, do you know anything about this case?
No, I have no idea.
Why were you hired as an expert to testify in this case?
I was hired to do the science behind domestic violence and inform the jury about what domestic violence is on a deeper level than just what the community members know at this point.
So as a general expert.
Yes.
Now, can you please tell the jury your work with the Georgia Coalition of Domestic Violence?
So when I worked at the Georgia Coalition Against Domestic Violence, I was a training coordinator. So what I did with them is that I trained advocates on how to service survivors of domestic violence throughout the state of Georgia. That was a real focus, and also creating content and training material for advocates throughout the state of Georgia.
And did you ever work for the Florida Coalition of Domestic Violence?
Yes, during that time at the Florida Coalition Against Domestic Violence, I was still doing the same thing, but I had additional duties with the CDC. And I also had to monitor multiple domestic violence sites, grants, Violence Against Women Act, and all such, and reporting to the CDC and also reporting to the Office of Violence Against Women.
How long did you work for the Florida Coalition?
About 2 years.
And how about the Georgia Coalition?
I worked there about 9 to 11 months. Grant funding, it ran out, so.
Now, did you have direct contact with victims of domestic violence through any of your prior employment?
Yes, I started in the domestic violence movement in 2012. I was a community advocate community and prevention advocate with Harbor House of Central Florida. That is in Orlando, Florida. And I was with them for about 5 years. And that's when I made the most of my direct contact with victims.
You know approximately how many victims of domestic violence you've worked with?
Well, between hotline calls, face-to-face, email, training, well over 20,000.
Now, do you regularly attend trainings on domestic violence?
Yes, in order for us to stay certified, we have to be up to date on what is current. And every year I have to get like a 6-hour training from the right now the Georgia Coalition Against Domestic Violence, and the Prosecution Association does those trainings to keep those certifications.
What is the Fatality Review Board?
The Fatality Review Board basically is a board where we do a deep dive into domestic violence homicide deaths, and we see what services they may have touched or what may have not, and we try to figure out what was a better route for that personal survivor. And I've also worked with murder-suicide type cases where we figured out that the bulk of those cases are intimate violence related.
You conduct studies on domestic
Yes, outside of my current PhD candidacy, I also did primary prevention with the CDC, where we looked at a public health model to prevent intimate partner violence from ever happening to someone. And that was a very in-depth type research study. And we work with universities, we work with community members, and I oversaw 42 centers in Florida throughout that program.
You testified in Georgia court as an expert in domestic violence.
Yes.
Have you testified in Florida court as an expert in domestic violence?
Yes, 27 times.
How about Georgia, if you know?
I'm on what, 55, 56? We got what's 27 minus 60? 50, I'm a social scientist, I know. Yeah, something like that.
That was a funny experiment. We got like 9 different numbers out of the jury.
Yes.
Mr. Dent, our engineer, didn't even offer one.
Now, what is generally, after we ask the continuing expert, what is generally power and control and cycle of abuse?
So the definition that we go by for domestic violence or intimate partner violence is a pattern of coercive behaviors that is used to gain and maintain control over the survivor in the relationship. So there is a power dynamic that the batterer or perpetrator has, or one partner has in that relationship. And it is done to maintain control over the survivor and keep that survivor in that relationship and that power dynamic.
What is the cycle of abuse?
The cycle of abuse is, we basically use that for victims to show how they stay in these relationships long term. And it's a full cycle from engagement all the way to, people call it the honeymoon phase, but we are changing that. That's basically reconciliation.
Now, Your Honor, at this time, the state would ask Ms. Rhoda James to be deemed an expert in domestic violence, power control, and cycle of abuse.
Ms. Feely, Ms. Rios.
Yes, that's my question.
Okay, same process as before, ladies and gentlemen. I bet Ms. Beza will be back. We're focused right now on this question of qualifications.
Good morning, Ms. James.
Good morning.
Have not obtained your doctorate degree, correct?
No, I'm an actual candidate at this point.
Have written a dissertation on domestic violence, cycle of violence, or power control, correct?
That is my current dissertation. Those are in my current writings right now.
You have not spoken at any conferences regarding cycle of violence and power control?
Conferences, I have.
The only professional license you currently hold is a Florida registered clinical social worker.
Yes.
And that means that you're only able to provide social work services under the supervision of a licensed social worker?
No. What that certification is a mental health clinician, and I would have to be supervised to do diagnoses and such, but I do not do that. And I don't do mental health services.
Okay. Ms. Rios, do you have any objection to having Ms. James qualified as an expert in domestic violence, the cycle of violence, and power and control?
I do, Your Honor. She has not obtained her PhD. She has not or completed her dissertation, so I'm asking for her not to be deemed an expert.
Okay. As with the previous expert, I think you'll be able to argue those things in terms of the weight the jury ought to give Ms. James's testimony, but I don't find a pending PhD to be disqualifying, and I will qualify Ms. James as an expert in the field of domestic violence, power and control, and cycle of violence. I think those were the 3. They're all intermixed. I think the jury knows what we're talking about.
Ms. James, can you please define domestic violence?
Domestic violence or intimate partner violence are used interchangeable, is a pattern of coercive behaviors that one partner in the relationship uses to gain and maintain control over their other partner.
Widespread is domestic.
At this time, is 1 in 3 women will experience domestic violence. And I believe we're at 1 in 4 men now. It used to be 1 in 9 about a year or two ago, but reporting has been climbing. So 1 in 4 males will experience domestic violence in their lifetime.
What are some common misconceptions about domestic violence?
The biggest common misconception is that the abuse will end if the person just leaves the relationship, which is not true, because when you leave the relationship, it's a loss of power. So that's the most vulnerable and lethal time in the relationship, when someone is trying to exit. And also when a firearm is introduced, that goes up 500 times of being a homicide victim. So it is not the safest time of the relationship.
Based on your training and experience, what do most people believe about an individual who remains in an abusive relationship?
They believe that they want the abuse, or somehow want to be abused, or they enjoy that type of dynamic. But if we go back to the definition, there's a power and control dynamic. It may be fear, children, economic. There's reasons why someone would stay in those type of relationship, and it's not just, I want to be in this relationship.
Now, you previously testified to the cycle of abuse. And I would like you, would a demonstrative help you aid in your testimony as to further explaining the cycle of abuse to the jury?
Yes.
You said cycle of abuse. Is that the same as cycle of violence?
Yes.
They're interchangeable?
Yes.
Okay.
I want you to look at State's Exhibit 57. It's on your, with that demonstrative.
Okay, we're going to pause for the calls, because at this point we have hit our super chat, super sticker goal. Thank you so much, Pretty Glow Aesthetics, for your $2 super sticker. Thank you all for helping us grow and support this channel. I appreciate y'all. Happy Friday. And I just want to touch on this. This was real interesting, because I think this is a misconception I've even had. The biggest misconception, I put understanding, but it's conception, is that once the victim leaves, the abuse ends. That was real interesting, because I know when she said it like that, I thought that too. So we definitely getting a lot of good information, you guys. Again, thank y'all for the support on the Super Sticker Challenge. Thanks.
Help aid your testimony today.
Yes.
Okay. Your Honor, at this time, the state would like to enter into evidence State's Exhibit 57 as a demonstrative.
Ms. Rios, any objection to States 57 as a demonstrative? It's admitted as such.
Publishing at this time. Can you please explain the cycle of abuse, cycle of violence to the jury?
Yes, this cycle is what we use for survivors to show how the survivor is caught up in the relationship, right? So the first part is the tension building phase. Survivors know when their partner is about to have an episode. So, and during this tension building, there is a breakdown of communication. There's fearful, they're walking on eggshells, or to the public, it may seem that the survivor is subservient and that he or she is trying to maintain intimacy in the relationship, but really is that I know this incident is going to happen. And then we go to the incident. A lot of people feel as if the incident is only physical, but it's not. The incident can be verbal abuse. It can be humiliation in front of family and friends, blaming, intimidating, arguing, or it could just be a physical altercation and one of the partners is arrested. So reconciliation, this can be multiple ways, right? What we think about is the abuser apologizing, taking ownership, or like giving the survivor or partner gifts, but that's not what that is. This reconciliation, a lot of times the perpetrator will deny that the abuse ever happened, make the survivor feel as it's their fault. This is where we come into contact with survivors. You know, if the partner is arrested, we see survivors recanting. This is to say the spot where we see where survivors are putting money on what we call books at the jail. This is the part where it gets kind of mucky, where people think that, oh no, they love this person. No, they're trying to the survivor is being manipulated at that point, and they feel like it's their fault, so they're trying to resolve it. And then calm, like I said, we're trying to phase out honeymoon phase, because when you think about honeymoon, you feel like, oh yeah, it's a great time. No, it's just really the incident is forgot about. It never happened. We're moving on with our relationship. It's calm, and nothing is happening. This person is back to who they were when I first met them. So we're just going to move on. And then we go back to the tension building, because this is ongoing. Like I said, it's a pattern. So this is ongoing. Different tactics, different ways to keep this going and to make the survivor feel as if they're the blame, or they have some type of mental illness, or that they are in some type of psychosis, but it keeps going.
Now, are you familiar with the power and control wheel?
Yes, the power and control wheel is an evidence-based tool that we use with survivors to have them understand what intimate partner violence is and what their perpetrator or batterer or partner did to keep them in the relationship that's fearful, or them feel as if they have to stay, or it could be a survival skill in the basic needs of it.
And we're looking at the demonstrative of the power and control wheel help aid in your testimony and explaining it to the jury.
Yes.
And in your state's exhibit 56, will this demonstrative help aid in your testimony?
Yes.
And at this time, the state moves into evidence state's exhibit 56 as a demonstrative aid.
Ms. Rios, any objection to States 56 as a demonstrative aid? It is admitted as that.
Publishing it to the jury.
So although this evidence-based tool was created in the 1980s, this is an updated one. We continuously update this wheel to keep up with the times at hand. If you look at this wheel, you'll see that it's gender neutral. And also you'll see other factors on the outside that you may see that will keep someone in that relationship, or tactics that the abuser will use. And on the outside of the wheel, we see physical and sexual violence. Those are, you can be arrested for those things. Those are what the public sees. You know, we may see poverty, sexism, and all these other things on the outside. But what I like about the wheel is on the spokes, it shows things that you may not see, right? Using intimidation. And intimidation can be used in any type of way, just sitting a bullet on a counter. Emotional abuse, it's just not calling this person out of their name. Is also humiliation, degrading acts in front of family and friends, or make them feel as if they're less than. Isolation is a slow process. That means the abuser will have the survivor cut off from all support system, and basically want the survivor only to contact or be around them or people that support the abuser. And the minimizing, denying, and blaming is joking about it. It's like, that wasn't that serious. You're taking this too seriously. We were just wrestling. We were just playing, when in reality, it was an incident. Children is a major part of this, because using children is a very manipulative way to keep the survivor in a relationship. Any partner in a relationship, children are vulnerable, and you want to keep your children safe. So there are many survivors who will stay in a relationship because they feel as if the children are here. If I'm here and the children are here, then the children are safe, right? But then there may be a separation, and the abuser will use the children as a way to identify and stop the survivor. It could be exchanging messages, threatening to hurt the children. It's a lot of manipulation in this. Privilege can be anything now. That's why it's gender neutral. It's not just male privilege. It's privilege of basic needs, everything. Like, if this survivor was trans and transitioning, it is hard for medical services, and also the exposure of that may prevent a survivor from coming forward. It's a combination of faith, race, and culture that can keep that survivor trapped in that relationship and embarrassment from society. Economic abuse is more than just putting money in a bank account and the survivor having no access. I've seen survivors be economically abused where the batterer or the abuser will cut cords in their car so their car won't start, so they can't go to work. I've seen people calling their partner's job like 10, 15 times a day to get them terminated. I've seen survivors' credit be ruined. They'll put their name on different things such as cars. They'll put it on the apartment, and then now we have an eviction and all these other things. Allowance. I've had survivors be given an allowance of $20 up to $20 a week, and this is all the money you're gonna get. So basically, using economic abuse is taking any type of monetary, taking any type of way to create an environment where the survivor cannot thrive financially. And coercion and threats, coercion and threats is more than just threatening the survivor. We're threatening children, family members. Like I told you, we did the study on the fatality review of murder suicides. The abusive partner is threatening to complete suicide, and usually they will take their partner and their children with them when they do that act. And that's a real act, and it happens in many, many cases. Using the authorities, having law enforcement come to the home and threatening to tell them that you use the survivor used substances. And that's a whole nother area that we're researching now, how using substances is used against the survivor, although the perpetrator or the abuser did started the addiction, right? So all of these things inside this spoke and on the outside equals power and control. But we'd like to highlight this wheel because there are a lot of things that the public don't see, or is a deeper understanding than just physical incidents.
Now, you mentioned a lot of different things, a lot of different examples.
Yes.
Of how an abuser exerts his power and control over a survivor. First, why do you use the word survivor?
So survivor, well, in our movement, we use survivor or thriver. There are victims don't want to be labeled as a victim. And in society, you get to label yourself how you want. And some survivors decide to be survivors. They try to be thrivers. But in domestic violence homicides, we call them victims because they are now a victim and they succumb to their injuries.
In your expert opinion, you just went through a lot of different ways that abusers can exert their power and control over victims. In your expert opinion, are there a certain number of events that have to happen for a person to be a survivor?
No, it just has to be a coercive pattern. It just has to be a pattern, right? I know there are isolated incidents, but isolated incidents between couples and intimate partner violence is completely different. There is a pattern. We have reports of past history and family members coming in and saying this dynamic exists.
In your expert opinion, can abusers try to control their victims by using their property? For example, their cars without their permission?
Yes, that can be a part of economic abuse as well. I have to be to work at 9 o'clock and you take my car at 8:50 and I can't go to work, right? That's an economic abuse. Or I can't get the children to their doctor's appointments. I can't get them to school. It is a multitude of things where you can use property, you can use the apartment, locking the survivor out at random times and not coming home. Yes, this property can be used as a tool or a tactic for power and control.
Now, in your expert opinion, is it unusual for a victim of domestic violence to remain in a relationship with his or her abuser after the abuser physically assaults them? For example, pinning them on a bed.
Yes, that's the cycle of abuse, right? We just went through that where the victim or the survivor may feel as if this is their fault, that I deserve this. And ultimately, we can't forget about love. I mean, when you're in love, you think that these things are normal and that any type of lay relationship outside of abuse would may excuse their partner's behavior.
In your expert opinion, is it unusual for a victim of domestic violence to remain in a relationship with her abuser after the abuser verbally assaults them by calling them out of their name, like bitch repeatedly, or even calling them their ex-wife's name?
Yes, that is very common, actually, calling the ex-wife or the wife has died, their names and things of that nature. It uses as a self-worth tool that you deserve this and that you are not as worthy as I am in this relationship. So yes, all of that can be used to create an environment where the survivor feels that they deserve these things or they need to stay.
Now, in your expert opinion, do victims of domestic violence stay? And we talked about this a little bit because they rely on their abuser financially for money to help with rent or help with bills.
Yes, that's economic, right? Basic needs. That a lot of the number one cause of homelessness for women and children is domestic violence, leaving a domestic violence relationship. So of course I'm going to stay in this relationship if I have housing, if I have food, my children are protected as far as I'm thinking they're protected, and I'm going to stay and we're going to split the bills and things of that nature, but it is economic.
Now, at what point in your expert opinion do you see victims fighting back by either shooting their abusers or physically fighting back?
The biggest thing when they fight back, when survivors fight back, is fear of their own lives, right? Stand your ground. We have all types of laws around that. If you are in general fear of your life, you're going to fight back. Or if the children are being assaulted, you're going to fight back, right? That anyone would do that, even in intimate partner relationships.
And in your expert opinion, say the children were in the home, would you find it an oddity if the survivor fought back by, say, shooting their abuser?
No, it's not odd. That you're protecting yourself, you're protecting your children, you're protecting your life. And if it's a threat in your home, you're going to use any type of weapon, firearm, or whatever you need to do to disable the threat.
I have no further questions for this witness.
Ms. Rios, do you have questions for Ms. James?
Your resume doesn't mention any specific speaking engagements in the realm of domestic violence, sexual violence, and power of control, any specifics.
Yes, it does. It should be an updated CD where it has a whole list of conferences, a whole list of engagements and speaking engagements, and also it should have memberships and things of that nature.
Resume stated that you have testified in other trial hearings, correct?
Yes.
You only testified for the state of those cases, correct?
No, I testify for the defense as well.
How many times have you testified for the state?
In Fulton County once.
You only testified for the state in Fulton County?
Oh, you said for the state?
Yes.
Ooh. I will say for the defense, I've testified once for the defense, but in Fulton County, and I will say I had consultations with the defender's office in Augusta, Georgia, and also Oregon.
For the city, you go to ballpark.
The bulk of them, maybe.
So that was 20,000, or that
was survivors.
100 for the state.
No, that was discussed during qualifications. I've been brought in over 50 times, so I don't have an approximate number for you, but I do have experience with the defense.
So 50 for the state, 1 for the defense.
I wouldn't say that. I would say consultations, as far as testifying once, but consultations multiple times. Once.
You were an employee with the Fulton County District Attorney's Office for 4 years, correct?
Yes.
Is that full time?
Yes.
You describe yourself as a senior victim witness advocate, advocate and domestic violence trainer expert.
This is when I was with the Fulton County District Attorney's Office.
So right now you're doing a separate contracting.
Yes.
And when you were working at the district attorney's office, how many victims did you work with?
Ooh, so understand with senior, when you're doing a victim advocate, it is a multitude of victims, especially with homicide. It's not just one. So maybe 500, because I'm dealing with family members, and I remember a case with 27. So I can't give you a ballpark, but it's multiple than just that one victim.
Mostly women?
Yes.
Men report domestic violence less.
Yes,
The current statistic that you mentioned was 1 in 4 men have experienced domestic violence,
in their lifetime, yes,
but that number hasn't been increasing.
yes,
And you also stated on the direct, the most lethal time for a domestic violence victim, the most lethal time for them is when they're trying to leave the domestic violence situation.
yes,
And when a gun's involved, the chances of them, it being a fatal situation goes up 500 times, you said?
yes,
And that can go for male and female.
yes. That's why we use gender neutral terms.
You have not published any research on, power and control and cycle of violence?
Not directly, but I have published research on intimate partner violence.
You have not engaged in any scientific training on domestic violence, cycle of violence, and power control?
I have, and I also have conducted those trainings.
You do not have an objective set of standards and guidelines that you follow for each case, correct?
Each case is a separate entity.
You haven't talked with any of the witnesses in this case, correct?
No,
You have no idea about Ms. McCreary's social background?
no,
You haven't spoken to the responding officer?
no,
Haven't reviewed any police report for this case?
no,
Haven't looked at any academic studies for this case?
no, I haven't academic studies. Okay, no, I have not.
You didn't review any medical records from Ms. McCreary in this case?
No,
You look at any medical records for the defendant, Larry Lawson?
no.
Can I see that demonstration?
Which one? Power control or cycle of abuse?
The purple one, was that power control? That was. I had it, but
Let me pull it.
or maybe it was, I think it was the,
Power and control is
Power
your,
and control, yeah.
yeah, the wheel.
Let me
you
pull it.
have one in front of you, I have one here. So I know you said that it had been updated since the 1980s.
Yes,
And so with the update, just removing the male from viewing privilege.
no, actually, we have multiple wills. We have a will for healthy relationships. We have a will for intimate partner violence between the LGBTQ community and different types of sub wills where that happens in different populations. I just use this one as a universal.
The viewing privilege states, treating you like a servant, being the one to find generals. That's typically connects to male privilege.
No, not at this current time.
I don't see anything on this power and control will that accounts for mental illness, substance abuse, or reciprocal domestic violence. Is that
I see substance abuse on the outside. So substance abuse is a thing. Mental health is culture, language, homophobia. These things are on this wheel that we discuss.
it's just not one section for those things?
The section is on the outside because those are things we see.
Would you agree that someone suffering from any type of physical or mental disability is more likely to be a victim of domestic violence?
Yes,
Wait a minute. I gotta rewind it just a little bit because I want to hear what she just said, that definition or example she just gave. Hold on. My bad, but I gotta hear it again. Got to.
Have been updated since the 1980s.
Yes.
And so the update, just removing the male from using privilege.
No, actually, we have multiple wills. We have a will for healthy relationships. We have a will for intimate partner violence between the LGBTQ community and different types of sub wills for that happens in different populations. I just use this one as a universal.
Using privilege is being you like a servant, being the one to find generals. That's typically connects to a male privilege.
No, not at this current time.
I don't see anything on this power and control will that accounts for mental illness, substance abuse, or reciprocal domestic violence. Is that?
I see substance abuse on the outside. So substance abuse is a thing. Mental health is culture, language, homophobia. These things are on this wheel that we discuss.
It's just not one section for those things.
The section is on the outside because those are things we see.
Would you agree that someone suffering from any type of physical or mental disability is more likely to be a victim of domestic violence?
Yes.
Both the power, control, and cycle of violence are based on subjective and not objective observations, correct?
No, these are research-based evidence. These are evidence-based. These have been had qualitative research and is in science.
If it's possible that observations noted by one domestic violence expert would not be observed by another.
As far as these two tools,
Yes, or in your own cases.
this is a science. There's no, can you repeat that question? I'm trying to understand what you're trying to ask me.
As possible to notice, observation noted by Ms. Walker, who created the will, would not be observed by a different person in the same field.
As far as the qualitative data in the science, they will. This isn't just an observation or something that was thrown together. This took years to create these two tools.
How have you decided a relationship is one of power, control, or an isolated incident?
So we're looking at the definition that it's a pattern and it's coercive and there's a power dynamic between the partners.
So by talking to the people and their experiences.
Yes.
In a particular relationship, if power and control is not an issue, it wouldn't be relevant, right?
Relevant to
The power and control cycle, if there's no, one person has more power than the other in that particular relationship, it would not be relevant.
So when we think about the definition, we're talking about domestic violence and intimate partner violence in a coercive pattern. Isolated events happen, but that most likely would be in major cases. I would not be sitting here, but I'm just here to explain the science behind intimate partner violence and what we speak about in the movement.
If you're talking to a survivor, you're trained to believe that person.
Yes.
Does anxiety play a role in these incidents?
Society, how?
No, I'm sorry, anxiety.
Anxiety. That is a mental health diagnosis, and I cannot diagnose in the state of Georgia.
Are you aware that Donald Duncan, a leading critic of power control and cycle of violence models, published a series of books and articles critically reviewing these models and highlighting his findings being contradictory and data provided by the models that are relying on?
Yes.
Are you familiar with his work?
No.
Are you aware of any other critics?
No.
Are you aware of any known potential error rate for these theories?
No.
Are these models typically only used in litigation purposes?
No.
So your theory of intimate partner violence presupposes numerous incidents, correct?
No. That is a definition. I gave a defined definition.
In order to make a determination that the cycle of abuse or power control exists, you would have to have evidence of consistent with the power control will.
It would be consistent to the definition, because even though it may not be listed in this tool, it could be used. So we may not have everything here.
So you would, to support the power control, you would need history of different tactics used that are highlighted in this power control bill.
If I'm sitting with a survivor, yes. Not for courtroom purposes. We don't diagnose intimate partner violence in the courtroom setting.
No further questions.
Thank you, Ms. Rios. Ms. Beza, any redirect?
Smile.
Briefly, you were asked questions on cross-examination about potential victim with physical or mental disability.
Yes.
In your expert opinion, can someone with physical or mental disabilities also be an abuser?
Yes.
No further questions.
Ms. Rios, anything else? All right, questions from the jurors?
Yeah, you do that.
I do that.
Yes.
No, the jurors do that. I just facilitate it. Thank you, sir.
Really have enjoyed these two witnesses. They was very informative, easy to understand, and no matter what, they was standing very, very strong in they stances. They wasn't shaking or move. And like Winter says here.
Ms. James,
Let me see.
can there be two abusers in a relationship? And by that, I don't mean could one survivor have in his or her orbit two people abusing the survivor, but instead two people are in a relationship and they are abusers of each other.
So no. If we go back to the definition, it's one partner who has a power dynamic over the other partner. So in an intimate partnership, there's one who has the power, there's one who does not. That's just like in family violence as well. There's a power dynamic when parents have power over their children. So no.
Ms. Beza, can you put State's Exhibit 56, that's the wheel, up, please?
Yes. Oh, the parental wheel, not.
Not the cycle, but the wheel. And not the throat.
Yes. Give me 1 second.
Ms. James, I'll start asking the question, but it'd be helpful, I think, for the jurors to see 56 again. But the question is, the items that are on the perimeter or outside of the wheel would be what would be externally visible that I could see in a relationship those two people have, whereas things on the inside would be what the public wouldn't see.
In a sense, yes, because the inside spokes, and also remember that the spokes on the inside is not illegal. So you wouldn't see someone getting arrested for calling their partner names, right? You wouldn't see someone getting arrested for using economic abuse, or you wouldn't see someone, you know, even using children. You wouldn't, unless there's physical abuse or harm involved with those children, you wouldn't see anyone getting arrested or the public seeing this act. Usually the factors on the outside of, that's why they're on the outside, because these are very visible, right? Social services can be involved, and that's a very visible public act, right? So that's when I look at this wheel, that's why.
Can we put the wheel up?
So that you can see the outside is very much visible. But that doesn't mean that mental health is illegal. It's just very much visible, right?
I'm trying to put it up, Your Honor. It's contacting the server.
Oh, all right, technical issues.
Computer.
Thank you for your answer. We may get it up on the screen. We got one more question. You talked to the jury about how a single incident or maybe isolated incident separated by a significant amount of time aren't considered, and now I don't want to put words in your mouth, domestic violence, or maybe not the cycle of violence. Can you reconcile that with the notion that, well, someone can be charged with a domestic violence crime with a single incident? If I hit my significant other with a baseball bat in the face because we're having a fight, and that may be the only time we ever had a fight, that still can be characterized as domestic violence or intimate partner violence. But there seems to be a tension between the two things you talked about, and a juror, at least one, would like you to discuss
I can
that.
explain. So in the movement, you know, we're defining domestic violence in a different way than statute. Now, statute basically says if you live under one roof, you're going to get charged with family violence. If it is with children, if it's intimate partnership, if it's parents, you know, statute is completely different. When regarding statute and the laws is completely different. You know, I can't diagnose domestic violence for law enforcement. They get to make that call. You know, that's a separate thing. But when we're in the movement, it is a defined standard for us. And this defined standard is, I keep going back to the science, and it's research based, but I can see the confusion when it would be an isolated incident and they would get arrested for family violence. Now, like I said, we're talking about two separate things. That's statute. I can't control that. The movement can't control that. But the movement talks about the deeper science behind it. And that's why we make that separation. Did I explain it?
You said what you said. Ms. Beza, do you have any questions for Ms. James based on the things she just talked about?
Yes, Your Honor. And just to clarify, as one of the questions was
Welcome back to the box show.
timing between incidents. Is there a certain amount of, in your expert opinion, is there a certain amount of time that it has to happen between incidents for a person to be a victim of domestic violence?
No.
Be further explain.
So on average, it takes 2 years for physical violence to appear, right? So we're talking about this period of what I want to say, what we talk about in the movement, where they're giving this person all of this love, attention, and the manipulative part, the grooming part, right? So the grooming part may take 2 years. There's no time frame on how these incidents happen. I've met with survivors where there's only been one physical incident, and that physical incident was enough for them to stay in that relationship for 20 years because they keep remembering what happened that day. So.
No further questions.
Ms. Rios, do you have any follow-up with Ms. James?
No, Your Honor.
Okay, Ms. James, thank you for your time.
Thank you.
Ms. Beza, next witness
The state rests.
as forecast. Thank you, Ms. Beza. Ladies and gentlemen, we are at a natural break point because it's about 10:30, but we're also at a procedural break point when the state rests. There are a number of things I need to take up with.
Lady Steph, you know what? I thought about that myself. We often think the same. Well, we often have think along the same lines. I see. I'm always telling you to get out my type. But I was thinking that too. I was like, dang, I wonder if she gonna keep that ring in her face, you know, as she go further in her career, right? I thought that because she's so on point. But then it's like I'm looking at that Pearson, but maybe it's because our age, right? Our generation and things like that. And here I'm saying that with a mouthful of gold teeth in my mouth. Oh, here I am saying that with a mouthful of gold in my mouth. But, I understand also because I made that choice that I can be not taken as seriously in a professional setting. Like, I'm very aware of that. Exactly. It's kind of like how I think with tattoos. The more and more common tattoos are, because of my generation and things, I'm still of the mindset, that those take away, that they look at those things when you go into a job interview. That's why I keep trying to tell my sons, about these tattoos. I couldn't believe it when my son got this tattoo on his neck. I almost died. I am still dying a slow death about that one. Okay. And that was a sidebar, you guys. So far, this trial has turned out to be very interesting. We will be getting to a verdict today. Let me fast forward to here. The state has rested, and I am the first witness is going to be the defendant. Let's get to the state, y'all. Let's get to the defense. Girl, he got a lot of Christmas Easter suits. He got on his purple Easter shirt today. That must be his daddy or uncle back there. I bet you that man back there with that beard, goatee, he's some relation to the defendant. They look alike. In layman's terms, you could be getting beat every day, but when you fight back and you have that whip, that person ass, the police steps in, and you are the one charged with the mess. Oh, good. Winter, you own it today. I own it.
Thank you, Deputy Gordon. You all can be seated.
Absolutely, ladies. So.
All right, jurors, welcome back. It is time now to have me ask Ms. Rios to call her first witness. All right, Mr. Lawson, if you'd come on up, please.
Everything raised right hand. Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God? Glory and see. Can you state your name for the record?
Mr. Larry Lawson. It's MRLARRYLEWSON.
Okay, put soda.
Larry, where do you work?
Work at right now was a truck job. Now I work at a car wash, and I also work at car for 2 jobs.
Mr. Lawson, I need you to get a little closer to the microphone. Unfortunately, it moves up and down, doesn't move left and right. I mean, forward and backward. So
I work
keep a little
at
closer.
truck, LAWSON. I work at Carver and I work at, Dan's Car Wash.
Sorry, I was moving my microphone. That created a little rattle as well. So one more time, tell us where you work.
At Carver's and at Dan's Car Wash.
You have any children?
Yes,
How many?
2.
How old?
I have one that's 11, about to be 12, and I have one that's 5, by Kenisa McCrary.
On September 7th, 2022, strangle Miss McCrary.
No, ma'am.
Punch Miss McCrary.
No, ma'am.
Press your forearm against her neck, obstructing her breathing.
No, ma'am.
Physically assault her in any way.
No, ma'am.
How do you know Miss McCrary?
I met her in 2018 at a job after I got divorced from my ex-wife. You know, she was staying at my house off and on, and she found some papers that I was a TBI patient and that I had a conservator, and she helped me get rid of my ex-wife. So she went through the whole process, and she supposed to be my conservator, Kenisia, but they said she couldn't be my conservator because we wasn't married.
How long did you live together?
We lived together approximately about 3 years off and on, because I had a home.
Sure was having trouble hearing.
I said we lived about 3 years and a half.
Is it hard for you to speak up?
No, it's great.
Who else lived in the house with you and Miss McCrary?
Okay, it was Carmen McCrary. It was Anthony Prather. Also my son Aiden Lawson, and sometimes my other son would come over. And Diego Lawson would come over.
Would you describe the relationship you had between you and Miss McCrary healthy?
At first, when she was working, and she was taking care of me because I got kicked out of my house because my wife found out about her and how young she was. She kicked me out, and I started depending on Miss Kenisa because she was helping me out through everything. But when she lost her job, that's when the relationship plummeted. In that same summer of the year I got shot.
What were the issues?
Issue was always about finances. She wanted to do this, do that, and I couldn't afford it because I was on a base income.
Because of your disability?
Yes, and I get a check every month for the rest of my life, but it's get balanced through my conservator. And she pays all my bills, including the bills that was at Kenisia house. I get the check of remaining of it. And I wouldn't want to do what Kenisia want me to do. The situation would start to get violent.
Who would get violent?
Kenisia would get violent at me, calling me bitches, hoes, call CC. My mama said she's a fat hoe. Your mama should have swallowed you.
Did Miss McCrary ever physically assault you?
Yes. The same year, we was supposed to be going down to Orlando, 407, and I told her I didn't have all the money to go there. And she hit me, and she found out my secret. She hit me, and she found out my secret.
Secret.
Yes.
Can you explain?
I don't hit women. And then every time it started to escalate after that. She started pulling knives on me, jumping up and kicking. And I put my hand up in the air. You want to fight? I said, no, I don't want to fight.
How often did she physically assault you?
I said at least once or twice a month after the rent I got paid and the car loan I got paid.
It was nice to you until she got what she wanted.
Yes, it's something like that. Then I wouldn't want to do what she wanted to do. She would get aggressive. She knew I wouldn't hit her. Because my pops, before he passed, he told me, look in my eyes, told me to do 2 things in life. Don't never hit a woman. Okay? Because she gave you life and she make you duplicate. Okay? And never look box with a woman. Because she always got to have the last word. Give it to her. And I made that promise. I'm 50-something years old right now. I never hit a woman day in my life. Never been on my record. Never.
How often did she verbally abuse you?
That was awfully on occasion and the room and spur of the moment. Like I said, after all the bills get paid, that's when it comes. And then one time she'll kick me out. I leave, then when time to come back, she's like, oh, I'm sorry, I did this and that. I will come back. We have a child again. I thought it was my second chance to be with her and have a family, actually, to have a family. And then with my car, my brother wrecked my car. I had nowhere else to go. I usually get in my car and just go down to Savannah with my brother.
We're dependent on her for transportation.
I was paying the car note. And she wasn't even working at that time. That's when everything started going bad for us.
Send Ms. McCurdy a text the morning of September 7th, 2022.
Yes, I did.
Your Honor, I have in my hand what has been previously marked as Exhibit 3.
Objection, Your Honor, self-serving hearsay.
This is a message that he sent to Ms. McCurdy, and this is.
May we have a sidebar?
So we don't need to have a sidebar, but it's an out-of-court statement. And if you are offering it to prove the truth of the matter asserted, it doesn't matter that the declarant is here. It's an out-of-court statement. So if you want to ask Mr. Lawson about what was going on that morning, and did he and Mr. McCrary talk about things, at this point, that's how you need to go about it. And it may be on redirect after cross, there'd be a different basis for admitting that.
What did you say in the text message that you sent to Ms. McCurdy?
I told her that I was tired of the physical, the mental, the verbal abuse for her and her mother, who she had coming over my house all the time that I was paying rent at. She done spat in my face and bit me, okay? And I was tired of it.
When you say your house, Mr. Lawson, I want to make sure I understand. We've seen pictures and heard about apartment C7. Is that what you're calling your house?
Yes, I'm saying it was our house, but I'm saying I was paying the bills there, but I'm saying it was jointly ours.
That's fine. I just want to make sure I'm understanding the location you're
Yes.
describing.
So in the text message you sent her, you clearly indicated that you wanted to leave the relationship.
Yes, I wanted out of a relationship. And I hadn't paid the rent up for that month.
And what were the reasons? Oh, I'm sorry.
And the car note, I paid the rent for that month and the car note.
What were the reasons that you wanted out of that relationship?
She was too abusive. She was a nice, nasty kind of individual. When she was up, she was a beautiful thing in the world. She gave me anything I want. And up and down, she did everything for me. Even took me to the same Sam's and asked me to marry her. But I told her I couldn't do it because my finances wasn't straight yet, and I didn't want to enter into a bond. As a man, I can't take care of my family.
You remember what happened after you sent the text message on September 7th?
Okay, I came back to the house. It was silence. I went straight to the back, packed my clothes up. Okay. I called my ride, he didn't answer his phone. So I left him with VM. Okay, later on that night, I went to the store to buy a calling card using her car because she usually turns her phone that she gave me on her T-Mobile off when it's time for me to leave or to call somebody. So I had to get a flip phone. Yeah. So
Tried to leave before?
yes, I tried to leave several times, but I had no transportation because my car had got wrecked inside Savannah. The only opportunity I had to get out of the relationship was use her phone. She shut off for me. So that day, last time she shut the phone off for me, I walked from Welcome Mall Road all the way to Jonesboro Road, which is an hour with some change to get me a flip phone.
The last time you tried to leave, she shut your phone off.
That's how I know she could do it. I didn't know that. She turned my phone off. I looked at her, I said, really? And I left out the house and I walked all the way to Walmart and brought me a flip phone. And I told myself this will never ever happen again. Then she came up to Walmart and came and got me, said she was sorry, this will never happen again, blah, blah, this and that. And I said, at the age, I had about 16 years. I said, she young, she in love. I said, mistakes happen. I get back in the car, gets back in the car, when I go back to the house. Okay, next month, my conservator does the same thing. She nasty again.
So going back to that day, you went and got a loan, so she went and cut your, so you would have a phone if she cut it off. And you packed it back.
No. On the previous time I was getting ready to leave, she shut her phone off and I went and got a phone that day. But she came up there and got me telling me she was sorry. This never happened again. So I had retained the flip phone. For cases ever happen again, I have me a way to get out. Yes.
So going back to that day, what happened when you were at your home that you shared with Miss McCrary?
Okay, I walked in, I packed myself up inside the bag. Everything was solid. Later on that day, I went to Walmart to get me a calling card. Okay, I called my partner again. He didn't answer the phone. I left him a VM, a voicemail. I came back to the house. I sat down in the front room soup right there, living room. I sat down right there. Okay, Ganisa was coming from the back to the front. My phone rang. And he said he was on his way. I said, I'm going to the back to get my bags. I'm about to meet you at the gas station. It was up the street. It's not 2 to 3 minutes from up the street.
The he you're talking about, you keep referring to a partner.
Yes.
Who is this?
His name is Ernest Seabrook.
Okay.
He's a workout partner of me from New York. I know his family up in New York.
Partner like business partner or partner like this is a
Workout
good
partner.
friend of mine?
Workout partner.
Oh, workout partner.
Workout partner.
Okay.
So it was a workout partner.
Got it.
Ernest Seabrook, we from New York. We know some of the same people.
And what happened?
So I sat down, she overheard the conversation. So she ran to the door and said, please don't go. I looked at her, I stepped up. The time I started to go to the back, by the time I got a little, recliner right there, she attacked me. He fell to the ground. Now I was telling her not to hurt her, because I know if I hurt her, I'm going straight to jail. You see any marks on her. So as soon as I subdued her to a point, I said, look here, can we just stop this foolishness and let me go in the back, get my stuff, and go?
When you were tussling, she was attacking you, and you were just trying to stop her from attacking.
Stay. That's all I'll always be. Okay. So I gets up. She gets up, runs past me, and go back to the back room. Okay. By the time I get past the children's room, I look in our room. I'm not in the room. She coming out of the closet with something in her hand. And as always, I'm taking caution because she always like to grab this gun, but she never pointed this gun at me. But this time, she didn't grab the gun before, but she never ever pointed it at me. So I told her not even to get this gun because she's too ill-tempered. Okay, only thing she can do is kill somebody that look like us or hurt somebody in this house. So I went to the back of the room. I seen her coming out with something in her hand. She looked back at me. So I stayed right there. I wasn't gonna walk past her because she might have something in her hand detrimental to me and get away because in South Florida, they don't do their job. So I stayed right there. She pointed one at me, told me, get out. I said, Kanisa, please let me go in this room and get my stuff. She came out in the hallway and said, get out, voicers. Then I backed up a little bit. I pulled out my phone, attempting to call 911. It's I heard it was up. And I was on the other side of the hallway of the children's door. The door right here, I'm on this side. I'm bleeding. Next thing I know, I'm fumbling down. Next thing I know, I fell. Next thing, inside my left leg.
Can you show?
Right here. And the word.
And where was that? Where it hit anything major?
She had a homework. I got a problem in my leg for the rest of my life. And $150,000 bill.
How has that injury affected you?
It hurts. Like I can't really say it hurt like shut your mouth. It hurts.
Every day you're in pain.
Every day I'm in pain. And I work 2 jobs, 18 hours a day. I was taking Marta. Okay? And I don't have time to take my medicine sometimes. So I be in excruciating pain every day. But I still find time to send her money. Every time she asks me some money, I'm gonna send my son his money. She's asked me for $450. I'm gonna send that money to her because she had my child.
Do you feel like she used your child to control you anyway?
Objection, Your Honor, leading.
Overrule.
Yes. Like she told me that he needed $180 a week for debt care. But she also told me to text that he get caps in 3 weeks and told me to hold him at my own car for 3 weeks and she get caps. And I guess what I did? I still sent her the money. Because that's my child.
You got
Welcome back,
shot.
AJ.
Were you
Good to
able to
see you.
walk?
No. I had to go down. So my brother, he works at Memorial Sisters to Grady's. He get me a discount down there. So I was catching the bus from here all the way to Savannah.
I mean, I'm gonna clarify, when you got shot that day, were you able to then walk, like, what happened after you got shot?
After I got shot, I stayed still for a minute, then I stumbled, then I slipped on my blood, and I fell down. That's where I was when they came and got me.
You remember going to the hospital?
Yes, I remember the paramedic talking to me and calling my mama, and I remember Canisa said that something about jumping. I asked the paramedic, say, please do an alcoholic test, a blood test on me, so I could show them that I was not drunk.
At some point, did you lose consciousness?
I was going in and out of consciousness in the house. And I don't know who tied that thing around my leg, but I thank God for them, whoever did that. I would not be standing here right now. Whoever did it, I say thank you, because you saved my life. They say that whoever put that turn on my life, saved my life.
Now, did you hear anyone going in and out of bedrooms? Did you hear?
Yes. I seen legs going in and out of the room. I seen legs coming here and there, but I was going in and out of conscious.
You have a drinking problem?
I don't drink.
Any reason you don't drink?
I'm a Muslim. Somebody called me Al Amin. My father's name was Al Amin. I don't smoke. I don't drink. That come from my tea bath sometimes when I get tired.
How does
It's
the
like-
TBI affect you?
It makes me all balanced when I get tired. Sometimes I slur. That's how I get kind of slurry, sluggish. But I'm no violent individual. I never been no violent individual in my whole life. I never been no violent individual, especially towards a woman.
So you never pinned Kinesia down, Miss Curry down on her bed?
Okay. I'm gonna tell you the whole honest the truth about that. That day that incident happened, it was because Carmen McCurry claimed that my son and her son jumped her. Also accusations that when she happened at her grandma's house, her other two cousins jumped her too. And I was laying in the bed sleeping. They woke me from this here. And she told me to discipline my son. And I took him in the room and I asked him what happened. She said, you're not gonna spank him. She continued to spank Anthony. And he told me what happened. And I told her, no. She said, you're not gonna spank him? So I turned to a ghost. No. Then she started hitting me. Okay? We fell on the
Wait.
bed. Okay? As we were struggling, I hold down and told her to stop. She spat in my face that day. And I called.
Wait. I got to say this. This man say that's when he turned into a ghost and he said, no.
My uncle, she called her mother over, and her mother threatened me, telling me I'm gonna go to jail for holding her down. After her daughter's got this spitting in my face, which I think constitutes as aggravated assault.
You were, again, you were defending yourself.
I was defending myself. I never put my hand on.
So don't talk over each other. You
Okay,
gotta wait
apologize.
until Ms. Rios finishes her question,
Okay.
and then you can answer.
Okay.
Now, after you were shot, do you ever remember talking to Officer Dickerson?
I ain't never seen, I thought it was a female.
Ever talk to Officer Burrell?
No,
Did any law enforcement officer come
No.
talk to you?
I've been inside the hospital for a whole month. I've been inside jail for a whole 6 months. I had a leg monitor on me for a whole year. That the prosecutor came and helped me get off of because she said, Kanisa said this only happened one
The
time.
relevance.
Only answer the questions.
Okay.
Ms. McCurry did know about your TBI injury.
Yes.
No further questions, right, Sean?
Ms. Beza?
Yes, Your Honor. Mr. Lawson, let's start at the end. You were describing the incident in which you pinned Ms. McCurry down on the bed, correct?
So I didn't pin her down. We were struggling and I was trying to get her control of the situation. And she
You're
spat
trying
in my face. I was getting control of the situation. And when she spat in my face, I got off of her.
So she spat in your face to get you off of her because you're trying to get control of her.
You know, I was trying to get control of the situation without hurting her or hurting myself.
Either way, you said it came about because Carmen came at your son, right?
No, I did not say that. I said that she claimed, she woke me out of my sleep. Kanisa woke my sleep, claiming that my son and her son at the predator jumped her. And this story has been told again by her other cousins. 2 cousins say that she said that they jumped her also. So I just grabbed my son to find out the situation before I do any discipline. Something that they're doing right now, I was gonna jump quote my son. I was gonna find out his side and his side, her side, okay? Once I grabbed her son, and he told the same exact story that my son Diego told, and I told her I was not going to discipline my son. And she got erratic and started hitting me. What am I supposed to do?
So Carmen was wrong.
Not Carmen, Canisia, right? Carmen was wrong, but Canisia was wrong also. She started hitting me.
Like Carmen, do you?
I like Carmen. I brought her shoes.
Carmen, the child Carmen is what I'm talking
I brought her shoes.
about. But you also yell at her, don't you?
No,
It's your testimony today that you never yelled at Carmen.
no, I have a loud voice. I never yelled at her.
So if there's a recording of you yelling at Carmen.
It's not a recording.
You?
Hold up, no suggestion. I'm talking recording of me doing what to her? I never ever dealt with Carmen. I always deal with the children, the men of the family.
You also testified on direct examination that you, when you were shot and you were bleeding out,
Yeah.
that you asked the paramedic to do an alcohol test on
I
you.
did.
However, you also testified that you never actually drank alcohol because you're Muslim.
I said I don't drink alcohol.
Because you're Muslim.
Yes.
So an alcohol test wouldn't even be an issue on September 7th of 2022, would it?
Wouldn't, because she said that I would drink it. I told him, give me an alcohol test.
Yet you're alleging now that you begged the paramedic or asked the paramedic to do an alcohol test on you when alcohol wasn't even an issue.
Yes, ma'am, because that's what she claimed.
Isn't it true that you only thought of this concocted story of an alcohol test from sitting through this trial and hearing witness after witness say that you were drunk?
If you go back inside and ask my lawyer, Jennifer Hansen, she will tell you I asked for a blood alcohol test inside jail, ma'am.
Now, you also stated on direct examination that Kanisia needed $180 a week, or you gave her essentially $180 a week money for Daniel.
Not every week, but I gave it to her when I had it.
So she depended on you financially,
No, she didn't. She had her own money.
but you still gave her money.
I gave her money because she had my son.
She relied on that money, correct?
No. We wasn't even staying together at the time. I was staying at my uncle's house.
Now, when you went through the story of what happened on September 7th of 2022, you were telling a story about how Kinesia attacked you and you subdued her and all of these things, correct?
I didn't sue nobody. I protected myself without hurting her.
But she was hurt, wouldn't you agree?
I didn't never hurt Kinesia.
Her lip was busted.
I didn't hit it.
You saw exhibit 11, you saw the body cam footage, correct, in this trial?
I seen about the camera, but you were speaking hearsay. Was you there? I was there.
And her lip is actually busted and bleeding. Wouldn't you agree from the exhibits that were presented to this jury?
Self-made, not for me.
Self what?
Self-made, not for me.
But it was self-made sometime between the shooting where she's helping you on the ground and her put in handcuffs, escorted to the car. Sometime in that time of helping you.
Help me do what?
she busted her lip.
Okay, repeat the question again, man. You gotta talk a little loud. My ear kind of trapped deaf in this ear. Speak a little louder.
You don't need to talk. You're plenty loud. Just
Yeah, please go talk.
break it down into
Okay.
smaller
Yeah, I
pieces.
can't hear. Can't hear what she's saying.
Okay, listen up.
Maybe turn the other way and I'll speak in this ear, okay? Now,
Wait a minute. They are throwing bows up in here. She said, well, can you turn this way? I'll speak in your other ear.
you're saying that she punched herself in the lip?
I didn't do it. I don't know how it happened. I didn't do it.
Oh, so you just don't know how it happened.
I got pictures in my hand though.
So now, do you remember, or isn't it true that, because you missed this part of your story that
So
you said on the stand, that you pushed Carmen out of the way when she was saying, get off my mom?
Carmen wasn't even in the room. It was in the room. Carmen wasn't out there.
So you're saying that Carmen's testimony yesterday about how she came out of the room and she was telling you to get off her mom and you kind of shocked her, she didn't fall, but you shoved her out the way, she made up that whole story?
Okay, check. Any time?
Just like you had plenty of time to make up this
Anytime.
concocted story you did
No,
today.
ma'am. No, ma'am.
Now, you also stated that, well, you said a lot of things, but one thing was that you were shot in the hallway, you stumbled down the hallway and fell in the living room.
I slipped.
Slipped
I slipped.
on your blood, right?
Yes.
Shot in the hallway,
Shot in the hallway.
stumbled down the hallway, that's that blood in the hallway,
Yeah, I stumbled down there.
and you fell in the living room.
I fell. I don't know where I landed there, but I fell.
Fine. You saw the pictures, correct? Would it be safe to say you landed where that pool of blood and towels are in the living room?
I didn't really recall that, but I'm saying you could say that. I don't know where I felt that.
Mr. Lawson, do you realize that the physical evidence in this case goes completely against what the story you just told?
No, I don't.
Okay, well, let's go through the physical.
Let's go.
You do realize, and isn't it true that the shell casing that was recovered inside the bedroom in the corner by the window?
I wasn't shot in the room.
Okay, and isn't it true that but there's blood located in between the TV stand and the bed in the bedroom?
That is not blood. That is wine that has been running for long periods of time. If it was blood and I got shot, there wouldn't be a trail of blood from that spot all the way to the door. I got shot in my main artery, ma'am.
So now it's wine. This is the first time
Oh,
we're
no.
hearing about wine.
No, I'm telling you what that is on the floor. Y'all doing speculations of this thing. The officers didn't do their job. I did not get shot in that room, ma'am.
Isn't it true that Kinesia, with what the physical evidence shows, saw you as she was in the corner, the bullet traveled through you into the TV stand, and you stumbled out of the room? You can follow the blood.
No, ma'am. I didn't get shot in the room at all. I got shot in the hallway. She came outside of the hallway and shot me.
So despite the physical evidence disproving this story you're telling, you're going to stick with your story.
Ma'am, I'm telling you what happened that night.
You do realize there are no shell casings in the hallway, right?
You realize that the officers didn't do their job. They didn't come see me at all.
Do you realize that there are no shell casings in the hallway?
I don't know, because I know the bullet came out of my leg, though.
You're right, it came out of your leg into the TV stand.
No, it came out of my leg. Tell me he had scraped it out of my leg.
Convenient, Mr.
No, ma'am. Ask the doctor.
Don't talk over each other.
I apologize.
And don't comment on his answers. Just
I
ask
apologize.
questions.
Yes, Your Honor. Now, next question, in the beginning of your testimony, since we are working backwards, right? So now we're at the point where you said it's at that same Sam's Club that she asked you to marry her. Do you remember saying that in your
It's true.
determination?
True.
Was this the Sam's Club in which you left that one time and drove erratically all the way home to scare her because you were unhappy? And
That never
tried to
happened.
talk to her?
That never happened.
So that's made up too.
It's all made up.
Okay. Now, you testified that you paid rent, you paid car notes, you paid
I could serve it.
for Canisia's lifestyle, correct?
No, my conservator paid the bills on my half for me staying there. I didn't pay Canisia a bill. She paid my half of the bills there.
But you did use her car, right?
Of course, I was paying half of the bill.
And you were trying to use her car even when she didn't want you to use her car the day of the incident,
No, I
correct?
had somebody come at the gas station to come pick me up.
Right.
She had her car keys.
Okay, you had someone, the random person named Ernest
Seabrook.
Seabrooks. Got it. Now, you mentioned that when your attorney, you sat through the trial, correct?
Of course, ma'am.
And when your attorney was asking Ms. McCurry to meet your question on cross-examination, she did not mention on your examination that you gave her money while you were in the hospital, right?
No, she requested money. I got a text message. She requested money saying that she didn't want to go back to her moms and pops.
And you gave it to her, correct?
Of course, she is my mother of my child.
And this was another time or one last time that you were exerting your power and control over her by supporting her financially, correct?
No, I wasn't even living with her.
You knew she depended on you financially.
No, I didn't.
But yet you still gave her money.
She has my child.
All of the time, correct?
She has my child. I'm always give her money. Today I die because she has my child.
Now, you started your direct examination with you did not strangle her, you did not punch her, you did not obstruct her breathing, you did not assault her in any way, correct?
Correct.
So this is your testimony today that the physical evidence actually on the scene, Carmen, Tunisia, everyone is just making up this story.
Yes.
All right, no further questions.
Ms. Rios, do you have any redirect for Mr. Watson?
No, Your Honor.
Come on, jury.
Are there
Ask a question.
questions from jurors for Mr. Watson? Looks like we've got a few. You?
I know they're gonna have some smart ass shady questions. I just know it. I can't wait. I know they're gonna ask some questions about what he think about the money and bring that up. I know somebody ought to ask him, what does hurt shut your mouth?
All right, Mr. Watson, you can be at ease, as can the jury. Will be back in here in a little bit.
I can move. Yes, I can go to the restroom.
Why every time one of the court employees stand up and go by that wall, they get to touching their toes and stretching and stuff?
Thanks.
This was very, very interesting. And he believed and standing firm on everything he's saying. Trust and believe that. He think he 100,000% right. He is the narcissist that Pretty Glow Aesthetics been calling him since the start. Yeah, he's smiling at them now until they give him them smart ass shady questions they finna pose to him. Baby, he say, then I turned into the ghost. No. But I'm gonna have to tell somebody that. I'm gonna have to use that, okay? That just got stolen from Mr. L. Lawson. I forgot I had fast forward. I ain't gonna lie. I really did. I forgot I had fast forward capacities. It feels like I'm watching this in real time. Y'all saw him do his breathing exercise. Livy said she would ask him, "Why do we have footage of you purchasing liquor at the liquor store?" Not a trick question. Not a trick question. That shit would be funny. Right. He a Muslim. He don't drink. And that's why he got all these suits. I believe he a Muslim in the Nation of Islam. It is some mighty FOI suits. Indeed. Here we go.
Mr. Lawson, have you ever reported to law enforcement any of the abuse that you described receiving at the hands of Ms. McCrary?
No, sir. I'm a man. I was kind of feeling kind of embarrassed because me letting a woman beat on me and then call it in. That's all it served to me. But I never knew it would go this far.
Can you tell the jurors what you mean when you say TBI?
I've been in a truck accident. I mean, traumatic brain injury.
Okay, traumatic brain injury is TBI.
TBI.
Do you receive benefits for the TBI?
Yes, I do.
Something like SSDI?
No, I got a workers' comp claim that they went through.
Workers' comp. So when you're saying you get money every month for the rest of your life, it's through the workers' comp settlements. Okay. Are you working right now?
I was forced to work because as Kanisa had informed me that my ex-wife was stealing all my money, that she helped me get rid of her. And she supposed to be in it, but they gave me another conservator and she doing the same thing, stealing all my money. So I'm getting pieces of my money every month.
So you covered a bunch there, but I'll ask, your ex-wife used to be your conservator.
Yes. Yes.
Then you got a new conservator who
Lou and Bonnie, and she is doing exactly the same thing. She is stealing my money too, but sending me partial money. Matter of fact, I got a check that she just sent me inside my bag if I can go get it.
Okay, no, you don't need to do that. And I think that was your way of answering you're being forced to work because you are telling the jury you're not getting all of your monthly payment.
No, sir. It's written inside my agreement. I don't supposed to be working at all.
Okay, but what about the working at the car wash and Carver's? That was what you were doing at the time of the incident, or that's what you're doing today?
That's what I'm doing now today.
Okay, so then let's get back to my question. You are working now.
Yes, I am.
Two jobs.
Two jobs.
Okay, how many hours a day?
18 hours a day. By the time I take Marlon to get from my uncle's house, it ended up to be like a 21 to 22 hour day for me. So I'm getting like 2 hours sleep, and I have to take my pain medicine, the Percocet, to give me for pain.
So you mentioned that you explained that you have not reported to the police, did not report to the police any of the abuse you allege Ms. McCrary did to you. You explained why. Did you ever seek medical attention for anything Ms. McCrary ever allegedly did to you?
No, I never did, because at that time I was in love with her. She done did so much for me. I ain't gonna lie to you. When I was down, she did everything for me.
Okay. The evening of the incident that brings us all here, did you have the keys to Ms. McCrary's car at any point?
I had it at first, but then she gained control of it when I was in the house. I gave it back to her. She had control of the whole car. She had the car keys.
Okay, so you had used the car keys to use the car to, I think you said, to go to Walmart to buy a calling card?
Buy a calling card for my minute phone in case she had stopped the activation on the T-Mobile card that she had on her plan.
And the incident that we've been talking about and the 911 calls were all around 7:30 in the evening that day. How far before 7:30 would you say you came back with the car keys and your calling card?
Came back, the possibly had to be like 7:01, 7:02, something like came inside the door.
Oh, I'm not asking you the exact time, but about a half hour before the situation
Before it happened. And I came inside the house and I sat down right there waiting on him to give me a call back because I left a VM on his voicemail.
Mr. Seabrooks.
Mr. Seabrooks.
Okay.
When he called me, she overheard him when she walked up. And I said, I was on my way down to the gas station.
So did you, after you got back to C7, having got the calling card, did you ever go into your bedroom and change out of your street clothes into your pajamas?
No.
While you were waiting for Mr. Seabrooks?
No.
Okay. How was it that the keys, which would have been on you when you came home, ended up, you said that Ms. McCrary ended up, I think you said, in total control of the car. She had the keys. How did the keys get from you to her after you got home that night?
I set them on the key stand right there by the door. I set it right there. And she came up. Like I say, she had possession. She ran to the door. She had possession of the car keys.
Okay.
And I didn't need the car keys because I was walking distant from the window.
Tell the jurors why you went back towards the bedroom where Ms. McCrary had run just before you got shot, as opposed to staying in the living room waiting for Mr. Seabrooks to call you.
That because I had my clothes inside there. I had my clothes already packed inside there. When he called me, I went back there. I was going back there, but she stopped me. She ran to the door and said, please don't leave. Okay, then I was going to go back there to get my stuff, but she attacked me and fell on the ground.
Okay. And then eventually you guys separated, and who went into the bedroom first?
I was going towards the bedroom first. She got up and ran past me.
Okay.
Okay. So I'm thinking this is another fool attempt for her to make me stay. Okay. So when I got back there, she coming outside of the closet with something in her hand. I looked in the room and she looked back at me. I said, my clothes inside there. So I'm not gonna walk past her because she done had a gun before. And sure enough, it was a gun. She pulled it out on me.
Got it. And you were shot while you were standing in the hallway?
No, she came outside the room and shot me.
Got it. So not only were you in the hallway, Ms. McCrary was in the hallway as well. Neither of you was in the bedroom when the gun was fired and you were hit.
I was hit. I was not inside the bedroom.
Okay. And tell the jury what you remember about Carmen, so Ms. McCrary's daughter, trying to get involved, maybe break up the tussle you two were having when you fell to the floor.
She wasn't even around, Jerry. She wasn't even around. They was inside the bedroom. All the children was inside the bedroom. She wasn't even around.
Was the air mattress, you may have heard there was some testimony about an air mattress that you used to lay on if you were watching some TV out in the living room. Was that out there the night all this happened?
It was, but what happened was that we had stopped sleeping together because she got so volatile about me buying her a king size bed to go inside as a queen size. So I wasn't gonna do that. So me and our son was sleeping inside the front room. It went on for like 2 to 3 months and we haven't slept together.
Okay. Ms. Rios, do you have any questions for Mr. Lawson?
No, Your Honor.
Ms. Beza?
Yes, Your Honor. This, isn't it true that your TBI or traumatic brain injury happened in 2002?
The truck accident happened in 2002. I became official TBI individual inside 2012.
So
You said
over,
2012?
That's when they officially recalled me as a TBI patient. I had the card. I got the Fulton County statement downstairs.
so 12 years ago.
Yes, 12 years, probably 13 now, 25.
Now, Judge asked you about, a question from the jury where you were going to Walmart, and you said that you went to Walmart in case she stopped your phone, correct?
84, yes.
Isn't it true that day you were out drinking, you actually didn't go to Walmart
I don't drink, madam.
or back? Now, you testified with, that Kinesia ran past you in the, right before you were shot.
I got a text message that's on there, if you would like to see it.
Ran past you in the hallway, grabbed something out of the closet, and you were shot in the hallway, correct?
Yes,
You were sitting in court here today when Carmen testified, correct?
correct.
And you heard Carmen say that she heard from in the bedroom, her mother go in the room, lock the door, and she heard you doing something in the kitchen and picking the lock, correct?
I heard her say that. Can we go back to the actual police statement? Because she never said it. First, she said, I followed her in the room. Okay. Then she could have gonna shot me. Then she locked the door.
Don't interrupt him.
Yes.
If you want to object to something, you
Yeah.
can, but he's going where he's going and you
I'm
can
saying-
follow up.
I'm saying in the second report, she said that I followed her and she tried to lock the door. If you want to have refreshment of this report, and I pushed it in and came. And then the last one, she said that I picked the lock of the door.
Whether you pushed the door and picked the lock, I'm talking about Carmen, the child, right? You heard her testify in court,
I
correct?
correctly.
And what you're saying today is that Carmen is just making this up, that her mother went in the room, locked the door, and she heard you playing with her, picking the lock. That's all Carmen just made up this.
That's a
story.
lie. And also according to the report, that is a lie. That's never been mentioned inside the report at all. Can I refresh your memory? Can I go over there and get the piece of paper, ma'am?
You may not, if someone wants to refresh your recollection, they can do that.
Okay.
Now, it's also your testimony that no one was in the bedroom, not you, not Kinesia, when you were hit, you were shot, correct?
Correct. She came out of the room.
Despite the shell casing being in the bedroom, despite reported blood that law enforcement saw being in the bedroom, your testimony is no one was in the bedroom.
Was that blood that they examined?
Is that your testimony?
Yes, it's that blood that they examined, ma'am.
You need to answer her question rather than asking her questions. Okay.
Now, my last question is, you said that you were packing your things in a suitcase. How big was the suitcase? What color was the suitcase? Was it a suitcase or was it a
So let's
bag?
do one question at a time.
What were you packing in?
I was packing inside a luggage bag about this big,
And what color?
suitcase.
What
It
color
was
was
like
that?
teal green.
Steel green bag?
I still have it.
You still have the bag. And how big was the bag? I'm sorry?
It's like a luggage bag.
The small, medium, large?
It's large.
Large bag. And where was the bag?
Inside the closet where Kinesia went back there and could retrieve the gun from.
You were packing in the closet and you kept the suitcase in the closet instead of bringing the suitcase, say, to the front door because you were leaving.
No, I packed the suitcase earlier when I came back from the gym. And everything was calm. I walked past her. She spoke to me. I never spoke to her the whole entire day. I packed my suitcase up early that day.
And left it in the closet as opposed to putting it on the floor, putting it by the door because you were leaving. You left it in the closet.
I called my individual, Ernest Seabrooks, and asked him, could he come get me? I had to leave a voicemail. I didn't know he was coming to get me.
Did you leave the suitcase in the closet the whole day after you packed it for something?
Yes, I did.
No further questions.
Yes, I did.
All right. Mr. Lawson, thank you for your time. You can return to your seat.
Thank you so much.
Ms. Rios, next witness.
Baby,
Thanks, rest.
baby.
Ms. Beza, well,
Okay, we at the 2.5, almost a 2.5 hour mark, and we're gonna get these closing statements, and we will be getting a verdict. This has proven. Well, I'm gonna let you guys tell me what you guys think. That was a very invigorating testimony. I mean, it had me on my toes. Let me say a whole mess. Witness say he went to Walter's liquor store and thought it was Walmart. But maybe, he a TBI patient. He is a TBI individual.
We need to break for lunch, ladies and gentlemen. The defense has rested. I need to talk with the
Everybody have
lawyers
rested.
about a few things, and the lawyers and I need to have.
So
It
now,
sounds like the state just got it.
Yes,
Do you have?
we're finna get to closing arguments. Please hit the like if you have not hit the like. BA says a hot mess on the defense side. Tanya laughing. Living says he's I know you fucking lie. Wait a minute. He say, do you need, he say, can I go get you a refreshment? Ma'am, you need a refreshment? Girl, a refresher. And why he kept asking, can he get off the stand and go get some? He went to go get his check out his pocket.
Okay. Ms. Rivers, are you ready?
Ah,
Let's go back on the record in State versus Lawson. It is a little bit after 1.
ooh.
And Ms. Beza, did you decide over the lunch break? Not that you necessarily
I
had
just
lunch.
say TBI stand for total
What you plan to
bullshit
do in
idiot.
terms of rebuttal evidence?
Yes, Your Honor. So the state has a recording in which,
Wait a minute, totally. Wait a minute. I'm gonna say to be ignorant, TBI. Okay, let me let this play.
you may not have the correct witness to introduce it at this point. It's a recording that LaTanya Hopper got from her niece, Carmen, of the defendant screaming at her. LaTanya's not here. We have Kanesia here who can identify both the voices, but I'm not sure she can lay the proper foundation as she can only know via hearsay or
Man,
guesstimate
we don't
when the
need to
recording
record.
was.
It's unnecessary.
But she does know it's the defendant's voice, and she knows it's her daughter's voice. She knows when LaTanya sent it to her.
Exactly,
That's
winner.
about it.
Okay, but otherwise, it's hard to pinpoint when the yelling happened.
Very true, Sean. Because
Okay.
maybe he wasn't drunk. Maybe that's
right.
why he was slurring.
So
and
given
making
that,
working
what's your
18
plan?
hours.
My plan is to see if there's an objection to the recording and then decide whether or not I'll put her on the stand to testify as to just the recording, not rebutting everything the defendant said. I'm not going to re-victimize her. It's just this one recording.
Okay. Have you, Ms. Rios, had a chance to, did you question Ms. McCrary when she testified? You guys can divide it up however you want, but have you had a chance to listen to the recording?
Yes.
Okay. And you just got it today. It sounds like the state just got it today, but it's also rebuttal evidence. And so query what the discovery rules are on that anyway, but it sounds like the state just got it.
Yes.
Do you have an objection to it being admitted as evidence and then published to the jury through the witness, Kanesia McCrary?
Yes, we both have an objection to it being introduced to that witness.
You only need to, only one of you needs to object, and you can do it, but it doesn't need to be that you both object.
So we object both to the lack of being able to authenticate it, and also I think it wouldn't pass the 404-403 analysis, which the court would have to hear first, but
How long is it?
it's not very long, but it's, the probative value is very much outweighed by the prejudicial effect.
Because of what's being said?
Just the fact that we don't know any context at all, it's just yelling on a voicemail or whatever it is.
Okay. It seems like it's probative because it would, if it's what people say it is, it would directly contradict something Mr. Lawson said. And so that makes it to me seem like it's pretty darn probative. But only if.
Okay, so I'm gonna fast forward. Let me give a sidebar real quick. My sidebar, and I have got to get this recorded this weekend for you guys. Our mascots, Apollo and Rock. Apollo has literally learned how to get the best of Rock when they playing in roughhousing. So he runs and Rock chases him, and he has little cubby holes everywhere in the house where he ducks into. And it frustrates the heck out of Rock. It is so funny. Anywho, I just wanted to share that with you guys. But every once in a while, Apollo be trying to Speedy Gonzalez into a little hole like a little rat, and Rock catch him. So if y'all hear the dogs, they roughhousing. Let's see. I be talking about. I just have to tell y'all this. To everyone in the clouds, welcome here on Trial Watch with Demetra. I am the Honorable Judge D. Lit. I am self-proclaimed, self-titled. And the chat that you're seeing that's very boisterous there is the Lit Lane Jury Box. Thank y'all for joining us. Make sure you're subscribed. Make sure you hit the bell. And of course, even though we're quite boisterous down here in the chat, feel free to drop down and make yourself known.
If I go past an area where you have a question or concern, let me know. And Ms. Feely, I did get your email. Thank you. That's very helpful. And I think I'm going to incorporate, I haven't yet because of the call I was on, but I think I'm going to incorporate exactly what you asked for, but we'll get there. All right, let me see if I can make this move.
Yes, Your Honor, the state calls Tanisha McCrary.
Right.
They didn't call her when she wasn't ready. All right, they recalling the victim / girlfriend.
We should swear in again, just a different day.
Thank you, raise right hand. You swear affirm that the testimony you give the truth, the whole truth, nothing but the truth, so help you God. So I see. You state the spelling name of the record.
Tanisha McCrary, Kanessia McCrary, McCrary.
Hi, Ms. McCrary, how are you?
I'm well. How are you?
Okay. Give me 1 second. Prior to you being called as a witness today, or right now, did you have a chance to listen to a recording?
Yes.
And did you recognize, how did you obtain that recording?
From a relative, from LaTanya.
LaTanya Hoffer, your sister?
Yes.
And in that recording, did you recognize any voices?
I did.
Whose voices did you recognize?
Carmen and Mr. Lawson.
And did you have a chance to listen to that recording and sign the CD?
I did.
I'm coming up and handing you State's Exhibit 78. Do you recognize State's Exhibit 78?
Yes.
Okay, and what is on that CD?
My signature.
And is this the recording that you had just testified to?
Yes.
And did you listen to this recording in full?
I did.
And did you recognize the voices that you just stated?
Yes, I did.
Your Honor, at this time, the state moves State's Exhibit 78 into evidence.
Ms. Rios, beyond the foundation and relevance arguments that you raised outside the presence of the jury, objections that you made outside the presence of the jury, which are preserved and carried over to now, do you have any other objections to the admission of State's 78?
There.
Okay, it's admitted over those objections.
Publishing at this time. We're going to stop at the 10-second mark.
I can't read it. I take a minute. I'm not talking to anybody.
For the portions that was just played, the first 10 seconds, whose voices were those?
My daughter Carmen and Mr. Lawson.
No further questions.
Ms. Rios, do you have any questions for Ms. McCrary? All right, any questions from the jurors? Seeing none, thank you for coming back. Ladies and gentlemen, the evidence is now closed. You have heard all the witness testimony you're going to hear and received all the exhibits that you are going to have back in the jury room.
We're going to get to these closing statements. And then we're going to get the verdict. And then we will be dismissed from court for the rest of the weekend. I know y'all hate to be off of jury duty for the weekend. But some of you guys know y'all gonna catch me on the other side of things. And I think what I need to do is on the weekend make sure I get a couple of uploads done, at least 2, so the channel can still be active over the weekend.
Larry Lawson tried to leave Ms. McCrary.
Or maybe
He
come
did
on.
not strangle her.
Oh,
He did not hit her. He tried to leave her.
You've heard me say a bunch, as I'll tell you more in a little bit. When
I'm sorry, I rewound. I didn't know they was
That
talking.
gives the state the opportunity to both open and close with closings, kind of to bookend whatever argument.
State's closing.
Larry Lawson tried to leave Ms. McCrary. He did not strangle her. He did not hit her. He tried to leave her. And for that, he was shot. He nearly bled out. He was criminally charged based only on her words. He was hospitalized for weeks. He was arrested on the warrants that were taken out while he was unconscious in the hospital. He's been coming to court regularly, waiting for this day.
Wait a minute. Wait. This sounds like the defense closing argument, don't it? The defense going first? I'm so confused. Hold on. Did I fast forward too far? Oh my God, what's going on?
Larry Lawson tried to leave Ms. McCrary. He did not strangle her. He did not hit her. He tried to leave her. And for that, he was shot. He nearly bled out. He was criminally charged based only on her words. He was hospitalized for weeks. He was arrested on the warrants that were taken out while he was unconscious in the hospital. He's been coming to court regularly, waiting for this day. All because he wanted to leave and Miss McCrary was not going to let him do it, except for in an ambulance. She has his blood on her hands. Compare that photo to the photos of Miss McCrary from this night when you're back there in the jury room. You heard from the state's own witness that men are statistically less likely to report domestic violence. It's just a fact. It's not manly. But you also heard from the state's expert that 1 in 4 men are abused. Who should really be sitting at the defense side? Thankfully, the burden of proof is not on Larry, since he didn't get to have any say in what happened because he was unconscious because of Ms. McCrary's shooting him. But finally today, the state has to prove it to you beyond a reasonable doubt. Oh.
Is it not advancing or it just wasn't the slide you
No,
wanted?
it's just not, that's fine.
Oh.
So I only get one chance to address you, and so I am gonna talk about the law. Without a PowerPoint. So the first part of, the first. All right, we'll talk about witness credibility then. Because you are going to hear from the judge that you determine witness credibility, and you alone. It's not for the judge, it's for you. Now, some of the stuff that you heard, particularly yesterday, that was the first time that we had ever heard it. And some of you actually may have noticed during the state's opening, we were kind of looking around looking at each other, because the things that the state claimed their witnesses were going to say, we had never heard. We thought we were missing a police report. We thought we had somehow missed some evidence, because what the state said in opening was so far from what was in Officer Farrell's statement, his police report, what was in Detective Dickerson's information. At no point in time had we heard that Carmen, who's mentioned in no police reports, said, "Oh, get off my mama," because that is really hard to hear, right? That's very heart-wrenching. But she never told anybody that we have ever been provided notice of. That was since she's been speaking with the state. Same with somebody's gonna die tonight, or somebody gotta die sometime, or whatever the quote was. We had never heard that Mr. Lawson was accused of saying that, because he didn't say it. And they never told anybody before this trial that he allegedly said it, because he didn't. So we were very much wondering what this trial was, when what we had was not what the state was claiming now that their case was. And we can think of all kinds of reasons why that could be. So when you're evaluating the credibility of witnesses, one thing that one of the experts did touch on was like the movement, right? Like believe all women, the Me Too movement. Certainly, that is wonderful for society that the pendulum has swung that way. And in your daily lives, it's a great movement. But in this courtroom, it has no place in a court of law where the standard is beyond a reasonable doubt. Believe women, support women. This court is about guilt or innocence and about facts that can be proven. And staying on credibility of witnesses, no one has more motive to lie than Miss McCrary. No one. The only thing I could possibly think of that would be more of a reason for her to lie would be if she was there and she was defending herself against a murder charge. Or would she have just told her story and gotten off of that too? Nobody has more of a reason to lie. The police got to her house and she had shot a man. We don't know how much time passed between that happening and her calling 911, but we know her mom was there. We know her sister was there. We know they're not stupid. You need to have something to say. Mr. Lawson's not saying anything. But she didn't kill him. And so now he's on trial. She claimed that she didn't remember asking Mr. Lawson for money while he was in the hospital, but she didn't deny it. Now let's talk about Carmen, because Carmen was obviously a star witness for the state. But the thing about Carmen is that she was never mentioned in police reports. She didn't give statements at the time. There's nothing that she said in the past because she didn't talk to anybody. So the thing about Carmen is she's 15 years old. This is a story that's talked about within the family, certainly. The state talked to her. So what did she say? Exactly what her mom said. Exactly. And I'm not saying that they coached her or she intentionally came in here and lied. I think what happened was that was a traumatic night for everybody. She was in the bedroom, but she knows what version of this helps her mom. So her story was she saw them on the ground. Mr. Lawson was choking her. And while he was choking her, because she testified very specifically, while they were on the ground, she claims that Mr. Lawson pushed her. That's when she says the push happened. And that's not possible, but it's helpful for her mom. The other thing that she was very specific about for a 12-year-old child witnessing this, and not somebody who's just hearing a story over and over, is she said, I saw the whole thing. I ran out of the bedroom just in time to see exactly where he was standing when he was shot. And it's where my mom wants him to be. And it's between the nightstand or the TV stand and the bed. Because that is really important for Miss McCrary's story, really important. But what really makes sense? She was in the bedroom with her siblings. She didn't see anything. She didn't hear what she claimed she heard. And again, she is not coming in here intentionally trying to mislead anybody. She just doesn't remember. But the way memory works is at the last time you thought about something, that's your last memory of it. So she's been thinking about this for over 2 years. She was very scripted. And it's because she was repeating a story that she heard and not something that she witnessed with her own eyes, that part. So as far as sympathy, I want to remind you all of 2 days ago, we were picking a jury. The state's going to try to argue, don't have any sympathy for Mr. Lawson. I didn't see a lot of sympathy for Mr. Lawson on Monday. I don't think that's where people's heads were at. And some of you were on a panel where there was a man who believed that to get to trial, somebody must have been guilty of something. When the fact of the matter is, Mr. Lawson has come to court over and over and over again because he can't come to court and say that he did this, because he didn't. Of course, it's easier to cop a plea. Innocent people do it in courtrooms like this every single day. Mr. Lawson couldn't do it. Some of you were on panels where there were potential jurors who found Mr. Lawson guilty sight unseen. They didn't know anything about the situation, and they said in front of you, I think he's guilty, not knowing that he had been shot, not knowing anything about the situation. And that's something that we knew we were going to have to deal with. We knew that 51 people were going to come in here, see Mr. Lawson. He's a big guy. He's a strong guy. And make up their minds before we got a chance to do anything. But you guys took an oath not to do that. We'll find out together what slide is next.
They all say sympathy.
So because this is my last chance to address you, I do need to talk about the law. And I'm going to sound like a broken record because it's just so important. But the standard here is beyond a reasonable doubt, which means a doubt from which a reason can be given. There's a lot of reasons here because of the topics. But for this, I want to point out to arrest someone, so to take out those arrest warrants, I think it's a stretch, but Detective Dickerson thought that he had probable cause to issue arrest warrants for Mr. Lawson based on what he had. This is down here to arrest someone. Now, at some point, the district attorney's office got it. Ideally, they would have done some more investigation. But here we are at trial, and there are multiple levels where you could have your child taken away. It's further down. And it doesn't take much imagination to realize why the standard is so high in criminal cases. Okay. So while we're talking about reasonable doubt and what it is, it's important to also talk about what it's not. It's a high burden, and if you and your fellow jurors are back there thinking, it's really suspicious, like why, I don't think the evidence is there. But if you're back there thinking, you know what, I think Mr. Lawson probably did what they're accusing him of doing. He probably deserved to get shot because he did what they're saying. Or maybe he did, or most likely he did what they're saying. If you're using that language, that's not guilty. And the thing about those phrasing is you don't have to fully believe not guilty. It's the state's job to prove it to you beyond a reasonable doubt. So it doesn't have to feel good. You don't have to like Mr. Lawson or dislike Ms. McCrary. Your job is to determine what happened and what can be proven beyond a reasonable doubt. So the judge is going to instruct you that the state has the burden of proving each element of the crime. And you're going to have this back there with you. So you have to each individually believe beyond a reasonable doubt, even though there's no physical evidence of it, that Mr. Lawson strangled her and that he intentionally, meaning it couldn't have been a tussle where she jumped on him, but he intentionally caused swelling and a bloody lip. These are elements that you must be convinced of beyond a reasonable doubt. Visible bodily harm by hitting her in the face. And the state told you in their opening that she was struck repeatedly. She was struck in the ear, she was struck on the head, she was struck in the face. And another thing the judge is going to instruct you is you don't have to leave your common sense at the door, right? I've never been hit in the face. But your common sense tells you if Mr. Lawson punched someone in the face, we wouldn't have to be looking carefully at those pictures to see where there might be an injury. We wouldn't have to look at a picture that appears to be a screenshot of a picture that they allege is from the next day that shows her lip. A little, maybe I can't even make it out. But if Mr. Lawson punched her in the face, those pictures would show visible bodily harm. The other thing that she said was she felt ringing in her ears. Another thing that we can't see. She doesn't have an injured ear. We don't have any pictures of an injured ear or any bruising on her head or face. And apparently she's capable of taking pictures of herself and sending them to the South Fulton Police Department. So if she did have any swelling or anything the next day, you best believe she would have taken a picture of it and sent it to them because she managed to do it with her lip. But you have to hold the state to these elements, including intent. And you heard all about what strangulation is and what it isn't. And the testimony was far from conclusive about what actually happened in that living room, but it was not strangulation. So the judge is going to instruct you that you have to reach a unanimous verdict, right? So you all have to agree, but you don't have to agree on why. You have to agree on your verdict. But you each may have different reasons today. And you're going to come up, you hopefully have more than I'm going to list off because I don't have unlimited time. But let's talk about some reasons to doubt. First, the lack of investigation. You should be pretty frustrated that in a shooting case, there was no investigation essentially. So Detective Dickerson, who should be ashamed of himself, and honestly, when he was sitting there, when his testimony was over, he bolted out the door so fast that the chair spun. I don't know if any of you guys saw that, but he bolted after his testimony that was frankly shameful. Didn't test any substances, didn't send anything off to be tested, didn't get Mr. Lawson's medical records to realize that the bullet was removed from his leg surgically, which he told you when he testified. He didn't test any suspected blood. He listened to Miss McCrary, and then he told his crime scene investigator where to look for evidence. He's the one. He tried to pass the buck and say, oh, well, the crime scene tech would have taken pictures of her face. The crime scene tech was like, well, the detective tells me what to take pictures of. So he was trying to pass the buck, but it was up to him. And what he told her was this shooting took place in the bedroom. So where'd she find one shell casing and one bullet? In the bedroom. Mr. Lawson was shot in the hallway, which you will see when you look at the pictures, the amount of blood in the hallway. We don't have a shell casing from the hallway because they didn't look for one. And she tried to waffle, oh, yeah, we looked all over the, well, they didn't find the gun box either. That she says was, Miss McCrary says was there. So I don't think they looked through the whole apartment. They had their theory and they collected evidence to support it, despite the massive amount of blood that Mr. Lawson lost in the hallway, leading towards the kitchen. It's a lot more convenient for the state. There's no evidence. There's a lot of evidence on many levels, but one thing that Ms. McCrary harped on was, I closed the door and locked it, and he picks the lock, and where picked it with what? This is a crime scene. You can't find like what was damaged in the door, how it was broken, because it wasn't. That door wasn't even closed, and he wasn't even in the room. Let's also talk about reasons to doubt witnesses who didn't witness anything. If you think about it, the only person who really witnessed anything is Miss McCrary. And then Miss McCrary told other people who then came in and told you guys what she told them. So just because a story is repeated over and over through different people does not make it true. It just makes it repetitive. She told her mom, she told her sister, she told her other sister. Those aren't witnesses. Those are people she told things to. Oh, I don't even know if I want to waste your time with a strangulation expert. She was clearly hired to come up here and tell you to ignore the evidence that this 200-pound man strangling Miss McCrary wouldn't leave marks. Do with that what you will. But that's all she came up here to say. Is don't worry about the lack of any scratches, bruises, anything on her, even though she was violently attacked. She was hired to do that, and that's what she did. Rosa James, again, just like the strangulation expert, never met Mr. Lawson, never met Ms. McCrary. Certainly wasn't there that night to give you any details about what happened. Very generic testimony. She was great. I'm sure she's a lovely person. She just doesn't add anything in this case in terms of actual evidence. She talked about the movement some. Again, there's no place for that when you're talking about a felony jury trial. And she actually told you that she is trained to believe accusers. She worked for the district attorney's office as a victim advocate, and you've seen victim advocates throughout this coming in now. They're all trained to believe accusers. She also told you that someone with a disability is more susceptible to being abused. And that when a gun is involved, the increase in fatality risk rises 500%, was what she told you. Who introduced the firearm into this situation? It was not Mr. Lawson. Mr. Lawson didn't even want her to get that gun. He could see where this was headed with their history. Ms. James also talked about an abuser isolating their alleged victim, right? There is not only no evidence that Mr. Lawson tried to alienate Ms. McCrary from her support system, there's ample evidence that Ms. McCrary's support system runs deep. Her mom and her sister live 4 to 5 minutes away. Her other sister lives 15 minutes away. She sees these people all the time. She is not a domestic violence victim. She does not fit any of the things that Ms. James talked about. She's not someone who would cut off from her loved ones. The state tried to make it seem like Mr. Lawson paying her car note was somehow controlling her. But you heard Mr. Lawson say he paid the car note and she let him use the car when she felt like it. She controlled the car. So it's actually sounding more like she exerted more control. Now, when Ms. Hopper was called, this was another inconsistency. She was called, best I could tell, just to corroborate that Ms. McCrary had a sore throat that night. And so the state got her to say, I got her some water when she was in the patrol car. And I guess wanting us to think that that was somehow evidence that she somehow had a sore raspy throat. But Ms. Hopper, when asked, testified only that what Ms. McCrary asked for was water because her mouth was dry. She didn't even mention anything about a sore throat. She asked her sister for water because her throat was dry. The number one reason to ask for water, because you're thirsty. Now, I don't even know if we need to get into why Ms. McCrary lied. She told you why. She showed you why. She didn't want to go to jail. She very successfully manipulated Detective Dickerson into not arresting her and into the district attorney's office, bringing this thing all the way to trial. So you all heard what she told Officer Farrell. Officer Farrell, just doing his job as the first responding officer, but there wasn't any evidence for him to collect. And we're not saying he did a bad job. There weren't injuries for him to photograph. There weren't injuries for the crime scene technician to photograph. They're really trying to tug at your heartstrings with this child thing because it is obviously, we're all sympathetic. We all have children in our lives. This is a tactic. They want you to think that Mr. Lawson is a monster. That's what this whole trial has been. They want you to believe he was a monster who deserved to get shot. Don't worry about it. So I get it. That Ms. McCrary claims that she couldn't possibly give accurate statements the night of because she was so worried about her children, even though her mom and her sister were with her children. Her mom testified to being in the room with, but she just didn't have the full story straight. She had enough to not get herself arrested, but she didn't have her full story straight. Officer Farrell. Nobody followed up, including the detective. We have no actual evidence other than Ms. McCrary's testimony about alleged alcohol consumption. And We also don't know what Ms. McCurry's BAC was, blood alcohol content. So let's talk about the CSI witness. We already touched on it. Horrible investigation, no testing of anything. She recovered the shell casings and the one bullet, or actually, I don't even think she recovered the defect, but it wasn't the bullet that hit Mr. McCrary as it was taken out of his leg. And she's probably great at her job, but she's led by the detective. So she did what the
Okay,
detective told her
AJ.
to. The Detective Dickerson already had his theory. And so she was a foot soldier. She collected evidence to support his theory. That was likely the first shot. Doesn't really matter in which order the shots were fired, but one of them ended up in Mr. Lawson's leg. All the new information that we already talked about, all the information that Detective Dickerson did put in his report. To take out warrants is one thing, probable cause. But to not even, I mean, Mr. Lawson had a right as a criminal defendant not to talk to the detective, but as you can see, wild horses couldn't have him off the stand. And if he had been given the opportunity before his arrest to tell the detective or anybody in law enforcement what happened, he would have. So again, the only time police were called was after she shot the. And this other, so when you're in a situation where you're accused of something like this, the state is allowed to bring out other bad things that you did in the past to make you seem bad. And that's what the state did here. He called her names. We deny that, but also why are they telling you that? Because they.
No, and I'm gonna object to this because the state did not bring that out to make him seem bad. That was not the pretrial ruling in which Your Honor allowed us to bring it out.
Okay, you're gonna get to argue the import and impact of that evidence in the same way that Ms. Feely is right now. You'll argue it differently, but you'll have the same opportunity.
So why I bring up that he called her names and that there was this other incident, it's because they lack evidence in this case. If they had enough evidence that Mr. Lawson did what they claimed, they would rest on her. They wouldn't just try to make him seem like a monster. And the same with the strangulation expert and the DV expert. They are padding this case so that you will overlook the fact that there is one witness who witnessed anything, and she has the most motive fly of any witness that I can think of. The state's theory that he was shot in the room really is a stretch when you start looking at how he was bleeding. They were coming in and out of the room once he's on the ground bleeding out. Was it blood? What was it? It was not blood from him bleeding out because he was shot in the hallway, and that's where the majority of the blood is. And I think you saw where he was shot. He was shot. He's not moving around after getting shot right in the kneecap, going back to his artery. You can see how much more exaggerated the story got from talking to Officer Farrell. And even on the 911 call, she knows she needs to come up with something. So, and then talking to the detective, and then the evidence that was on the body cam of, I have a bloody lip, and the officer saying, oh yeah, I see. You saw it? Then why didn't you take a picture of it? We didn't see it on the body cam. Yeah, not hard on this. The physical evidence just doesn't support being punched in the face or being close. It just doesn't. And once you find the lie, this is a woman who just shot somebody. Compare this to the blood in the hallway.
That do look like wine.
Use your common sense. You heard from Ms. James that the most dangerous time for a domestic violence victim is when they try to leave. He left all right. She's lucky to be alive. And I'm not saying that you have to not like Ms. McCrary to know that her testimony was what she needed it to be. Because for one thing, lying to the police is a crime too. So once you got your story out there, you gotta stick to it. You can exaggerate it more, but you can't come clean about actually that's not how it happened. He didn't attack me. I didn't want him to leave. So he didn't leave. But that doesn't change the fact that she shot an unarmed man and it went scot-free. Not only did she go scot-free, he, Mr. Lawson, who has already suffered enough, is on trial for the picture that you saw of her with no injuries on. I can't think of a reason why you would not let someone leave if you're scared of them. She blocked the door. She didn't want him to leave. But she was scared of him. One more witness, didn't witness anything, didn't witness any bruising or redness. No breathing issues. Didn't have to be checked out. So that little puddle on the carpet, because carpet can soak in some blood, or why does she lie about where he was shot? Why is she lying about all of it? The same reason. The judge is going to instruct you that a conviction is only authorized if the evidence excludes all reasonable theories of innocence and proves Mr. Lawson's guilt beyond reasonable doubt. We are so far below that. So all of Ms. McCrary's witnesses are related to her, that she brought that actually were not hired by the state. They were together for 4 years. But they know their loved one just shot an unarmed man. They too have common sense and knowledge. So Mr. Lawson has no burden here. The state had to prove his guilt beyond a reasonable doubt. Like I said before, he could not have been stopped by an army from testifying. It's his right to testify. He wanted to finally have someone here. He told you that he broke up with her essentially via text. She confirmed that she received that text that day. That's one thing we all agree on. He was trying to leave her. She got the text message. We talked about Miss James and Miss Williams and what they
It's 5
really
more
asked
minutes, y'all.
this
5
case.
more minutes.
The judge is going to instruct you that you are not to concern yourselves with sentence, with punishment, right? Your job is merely guilt or innocence. Did you have the indictment? You're going to have the indictment back there with you. Count 1, aggravated assault, a felony. Count 2, battery, physical bodily injury, a misdemeanor. So if you make Mr. Lawson a convicted felon, you have no say in how much punishment he gets or the collateral effects of a felony conviction. There will be punishment.
Objection, Your Honor, objection.
Let's move away from punishment, not anything the jury needs to dwell on.
To be clear, the witnesses in this case are either biased or add no value. This is exactly how wrongful convictions happen with this kind of evidence. And I've got to tell you, as Mr. Lawson's attorney, I'm scared. My PowerPoint's not working. Criminal justice system has gotten Mr. Lawson's case wrong every step of the way. Letting Ms. McCrary lie and get out of being charged herself by charging Larry on nothing but Ms. McCrary's self-serving statements. And then the DA's office, Fulton County District Attorney's Office got this case and crossed. And if you are wishing that we did have more evidence, you have got to find Mr. Lawson not guilty. So we are, as the defense, asking you to remember the bigger picture here.
Uh-oh, what did I
Mr.
do?
McCrary shot an unarmed man in the home they share.
Uh-oh. Child, y'all are incorrigible. Okay, y'all are incorrigible. Okay, so since y'all, you know, I failed to troll pressure. I failed to troll pressure. But look, I closed the first poll down. The first poll said, I want to show you guys something. The first poll said, did you vote? Uh-oh. Did I close out the first? Okay, the first poll said, did you vote on the community wall poll? 41% said yes, and an alarming 59% of you guys have came in and said no, you have not voted on the poll. That is indeed alarming. So I want to encourage you guys. Okay, if you don't vote, you can't complain. If you don't vote, you cannot complain. So let me show you guys what I'm talking about. Boom. The poll on the community wall. Okay, make sure to go hit the community wall up on this channel and pick A or B. The reason I did not put the Menendez trial up as an option is because we're going to do that after whichever one of these, because that's a longer trial. And so we just came off of a long night court trial. So please be sure, to the 59% who came through and hadn't voted, please go vote. Also doing a little housekeeping real quick before we get to the state, because the state is closing. I don't know why they're going out of order. Don't ask me. I'm gonna close down this poll that I have put up just now. I said, was that one on a bedroom floor? 29% said wine. That might be me who voted. And 71% of you guys said that's blood. The people have spoken. Boom. Thank y'all for y'all participation. Let me get back to the trial here. Okay. Let's do the magic. You went back and voted, Sassy? Okay. Hold on. Oh, Lord. What? Oh, Lord. What's going on? Why is it on mute? Hold on. Let's see. That's not me tripping with the screen. That's them tripping with the screen right now. Where did the bite come from? Why can't we hear anything? Hold on. Why? Oh, okay. Maybe that's them going through their slides. Oh, we can't hear. I don't understand why we can't hear. Let me check the. Oh, no, the volume is on. Let me check and see if I muted this tab. It's not muted, so maybe they had some type of technical problem. Apparently, yeah.
So like, I think I'm getting there.
There's been some body cam footage. If you want to review that, you need to let Deputy Gordon know, and we'll get that onto that computer and you can review it and discuss it as you're reviewing it. In the olden days, you had duty to acquit him, in which event.
Yeah, but her courtrooms have to.
Okay, so they out deliberating. So let's get to the verdict, which is not even this day. One moment. They might have had some type of audio problem, I guess. Let me take this down. Let me go here. And so it wasn't an open and closed case because to this jury anyway, because they took hours. Hold on. Okay. But Mr. McBurney got his green shirt on today. Okay, hold on. I'm trying to get to the verdict. They deliberated for a while. Okay, here we go. They're back in the court. They got a note from the jury? Hold on. Okay, let me let y'all see. Boom. Okay, let me take this off. Let's do this. Okay. And let's do this. Wait a minute. I think y'all talking about me. Hold on. Is y'all dragging me?
Ms. Rivers, you ready? All right, we are back on the record in State versus Lawson, and we have, it's not a question, it's a statement, but card number 4 from the jury. It reads, "We are still having issues deciding." And says there are 12 people who are set in their decision on one charge and not willing to change their minds. I was hesitant only because I tend not to share numbers with you all, but 12 is actually a number I can share. It's like 0. It's not a divide. My thought is this. I'd like to bring the foreperson out and ask the foreperson a few questions along the lines of, are people having a meaningful back and forth, or do you have a juror who's in the corner with her arms crossed saying, I'm not going to engage? Because if it's the former and they've reached a verdict on one count. And then there are 12 people who've made up their minds, but it is, I'm not going to ask the divide. It is not a unanimous decision that they've got. Some people are one way and some are the other. But they have been thoughtfully engaging, and they are at what this four-person describes. He or she will use their own terminology, but kind of a impasse, an immovable point. I think we are where we've gotten on this case. But we can discuss what decision I make based on the answers we get from that four-person.
For the cash app support, I appreciate
both sides are
that.
comfortable bringing the four-person out to talk about that. Ms. Beza, are you all right with that?
Yes, Your Honor.
Oh.
I'm all right.
Okay. Are you all right with that, Ms. Rios? All right. Can we bring the four-person in? They're just right outside?
Right outside.
Okay.
Okay, so why they getting that person? What do y'all think is the holdup or the hang up? What do y'all think that could be? Because I'm gonna be perfectly honest. I kind of feel like that lady was putting 20 on 10. I do feel like the daughter came out the room and got pushed in the skirmish. I think that's what really pissed her off, and she went and got that gun, which, hey, ain't nothing wrong with that. But I think because she ended up shooting him at that moment in time, she threw all
All
kinds
right,
of
you all
extra
can be
stuff
seated.
in
You
it
can be
to
seated.
show that she
Ms.
was
Beza stepped right outside. She was just
standing her
getting a few
ground.
folks.
I kind of get that feeling. Not saying that he just not
Good
guilty,
morning.
but I do
I'm
think
doing all right. How are you
like
doing?
the choking part was added on
Good.
there. I
I
kind
gotta
of
ask you a few questions about the state of affairs
Let's see what
in
they
the
say.
jury room. But I'd ask you to refrain when you are answering from saying how people have decided, by which I don't mean it was a careful thought process, but we've decided guilty, not guilty. Don't want to hear that. And also, if there is a division amongst you that is not 12-0, don't please share those numbers, that 8 people are going one way and 4 the other way. Don't want to hear that either. So first question is, my understanding is that your group has reached a unanimous decision as to one count.
That's correct.
Okay, and it's the other count about which there is continued indecision, may be the wrong word, but there's a lack of unanimity.
Correct. We've reached
An impasse, I like that word for this situation. Is the impasse, in your opinion, a product of good faith exchanges and backs and forth and people just disagree? Or do you perceive that one or more jurors are refusing to deliberate, not participating in the conversation?
No, it's the former, not the latter. We've had very good discussions and everyone's being very civil with each other.
Fantastic.
Yeah, and we've all, we got it set up, we're all stating our, what we want to talk about, one person talking to John McClellan. And so I feel like we've reached a point where some of the people that are on the other side, and what could change your mind? Is there anything that would take away the reason, beyond a reasonable doubt? And there's nothing right now.
Got it.
Yeah.
So that sounds to me as if you are saying you don't believe that another half hour or another 3 hours is going to change much, because you all have gone around and around, not once or twice, but multiple times, sharing respectfully the conflicting views and concluding that reasonable people disagree. And we've got 12 reasonable people. And as to that other count, it's just not one where there's unanimity. Is that a fair summary of where you are?
That's fair. I feel like if we stayed in there for another 2 or 3 hours, we would come back and be in the exact same position we're in right now.
Okay.
Yeah.
All right. Appreciate you sharing that. Ms. Beza, do you have any questions for our four-person?
No, Your Honor.
Ms. Rios? All right. Head on back. Thank you. Ms. Beza, do you have a suggestion as
that's
to what we
interesting.
do next?
I wouldn't have never thought this. Let's see what they say.
Allen charge might be beneficial. Next, although the juror did say if he's in there another 2 hours, it will be the same result. However, I've seen where jurors were at impasses in other trials and the judge read the Allen charge and they, came to a verdict either way. So I think the Allen charge may be beneficial if they're willing to
Exactly,
deliberate, say,
Winter.
till right after lunch. I know we have a lunch break soon.
Okay. Ms. Rios, what is your thought about how we process what we all heard from the foreperson?
I think we call it, I'm not sure what I said about the Allen chart is gonna make a difference if they're that much seems to be divided. Yeah. Yeah.
I couldn't quite hear her whispers, but maybe you'll translate them.
We can't force people to continue deliberating if it's not.
I mean, I can, but I don't want to because it's not productive. It becomes coercive and I wouldn't ever want, and I don't think Ms. Beza is saying anything to that effect. And no one's saying you were. So you don't need to stand up and say you're insulted by what you heard. But it is, I can make them stay there. But I find this was a very thoughtful foreperson. And I think this process has been blessed by a jury that is engaged and not tribal and saying, well, you're viewing it one way and I don't appreciate your worldview. Reasonable minds, and I think we've got 12 of them, they differ, and on one of the counts, not on the other. So you do not object, Ms. Rios, if I call this to a close and ultimately it would be declaring a mistrial as to the count where there's not unanimity, and then I'd be accepting the verdict as to whichever count it is where there is unanimity. You don't object to that approach.
Which charge do y'all think is going to be declared a mistrial? For me, I feel they're going to charge him with, I think they're going to find him guilty of the familiar, or how they put it, the family violence. And I think they're going to find him, I think it's going to be a mistrial on the aggravated assault. Like some say, when jurors cannot agree on a verdict, wait a minute. When jurors cannot agree on a verdict and report this to a judge, the judge may issue further instructions to them to encourage those in the minority to reconsider their position. Oh, like a debate to argue their point. Libman says, I think the Allen charge is kind of forcing them to come to a verdict. It kind of pushing them to work at it again. Okay. Winter's talking about, child, let them go home and finish trucking, drinking, and nursing that that souvenir leg. Child, he's slow, so they giving him mercy. At least half of them are. I think they're gonna find. Let's see. This is so interesting.
Okay. You'd prefer an Allen charge.
I prefer.
Got it. Okay. I'm going to accept the verdict that they have reached and process that with you all, and we will go from there. So have they filled out the verdict form? Okay, why don't you check with them? I'd ask you all to stay right here.
The lead bailiff is always feisty. And if she try to if she try to get me kicked off the bench again, she gonna find herself not being the lead bailiff, but the outside bailiff that's outside the door checking IDs.
First, was Mr. Dent on time?
Yes.
All right.
He was number 6.
Okay.
One thing for certain, two things for sure.
No doing this stuff.
These Quickie
But the
trials,
important part happened.
this one
My
packed us a hell of a
understanding
punch.
is
It was
that
good.
you all have reached a verdict as to one of the
Let me be
counts,
quiet.
and you are at an impasse as to the other count. Is that correct, foreperson?
That's
All right. If you would please stand. As to the count for which you reached a verdict, was it a unanimous verdict?
It was a unanimous verdict.
And have you completed the verdict form as to that count and signed and dated it?
Yes, I have.
All right. Will you please read the verdict as to the one count where you were unanimous?
For count 1 of aggravated assault, we, the jury, unanimously find the defendant not guilty.
And then count 2, which would be the family violence
that.
battery, there's
I
no
said
verdict included there. That's where there was an impasse.
There was an impasse for that.
Okay. All right. Deputy Gordon, if you get that verdict form to Ms. Beza and to Ms. Rios, please.
I called that perfectly, and therein lies. And
Ms. Beza, do you
therefore,
have any objection to the
I
form of
am
the verdict?
Judge
No, Your Honor.
Delit.
Ms. Rios? Okay. Anything else, Ms. Beza, before I excuse this jury after their several days of service?
No, Your Honor.
Ms. Rios? All right, ladies and gentlemen, I want to thank you on behalf of Fulton County, on behalf of both the state and Mr. Lawson and his legal team. You gave us 3 days plus a morning, so 3.5 days of your life. You
And I doubt very seriously, unless they just want to be super duper petty and waste taxpayers' money, I doubt very seriously that the state is going to pursue retrying the family violence. It's not like it was a history of it in multiple charges. I find it hard to believe that they're going to do that. So the verdict in this case, let me type it in, is not guilty of aggravated assault, mistrial on family violence, and also the victim, she had no criminal charges and she got off on the shooting. So like Living said, it's a wash. Like Living said, so neither one of them gets in trouble. Went to talk about she knew it, but she never did say, she didn't even say nothing. I knew it. Okay. Sean P said, not surprised at all. So there you have it, folks. This was an excellent. I love this little short trial. 2 days from gavel to gavel. We got through it from opening statements to the verdict. We are going to definitely get in a couple of. I'm gonna be on the lookout, and I'm gonna go find some shorter cases just like these to kind of put in. That way we can kind of get a break from the long, tedious ones. This case goes to show that there could be just as much jury conversation and opinion and finding out about the court system without spending as much time on longer cases. Absolutely correct. So what I would need to do, Lady Steph, is especially like because we have night court and day court, and the night court ones, it's it would benefit me to find and have a stockpile of shorter trials to put in, because it to me it seemed like it's kind of better to have like some shorter ones in the day to get through, to do and keep it moving during the day, and then the slow burn ones at night. That's how I think it kind of feels that way to me, so I'm going to be looking, and I have actually a couple of trials from this particular court that's shorter trials. So, and Judge Boyd's court will be a good one that I was looking through, but I just hadn't seen any interest. I got a couple of channels. I got a couple of courts that I'm looking at. We're going to get more quickie trials, as I call them, right? So before we say court is dismissed, we don't have night court tonight. I think y'all said the sheriff is winning so far. Y'all will have to see on Monday what trial it'll be. Okay. And I'm thinking when I am home and stuff like that on the weekends, when I'm not busy, I want to come in and do some arrest reactions. I like those arrests in body cam footage. Y'all know we've done. I like that. So I kind of want to come in and do that kind of thing on the weekend when I'm able to come on live. Because that last case that Demetri, girl, I know you're not talking about the burn pile trial. Y'all ate that burn pile trial up. Okay. Oh, are y'all talking about I actually emailed you the body cam of Marcus Jordan. Okay, we'll do that one. I love the arrest videos too. And it seems like I'm not getting to it much. Or maybe that's the kind of, y'all think that's the kind of content I can do? Maybe that's what I'll do on the other side. Live reactions like that. That way when I'm on the other side, I can get my content in and my clicks and views and don't have to be and I can keep this channel trial watches. How does that sound? See, I'm gonna have to start having my membership live so we can talk about what would be good. That's what we need to be talking our business. You know what I'm saying? Our production business in the members meetings. No, not. I thought about that. You talking about the love affair trial, girl. We gonna read. I didn't already spend too much time doing this background. I've invested too much time doing my background for that trial. Okay, so we will revisit it. That's something. I have a lot of things I have to do this weekend. So yeah. And we still went to 3 hours and 40 minutes. I thought I was gonna get a little bit shorter. Okay, living. Yeah, I'm just trying to get like a good flow of things, right? Because with the trials, those are like every day and it's consistent. I like, just doing it. And this is a trial watch channel. I think I'll probably do I could put up, I don't know. I'll figure it out. So I got the description part right. And I think I'm thinking about investing in TubeBuddy. That way it can like make sure that all my uploads and all my descriptions and stuff, once I get it set up. See, that's how she rolls. It's not boring unless it get bored to her. No, I get bored at the same time you guys get bored. But what happens is that I'm trying to exercise a little bit more discipline, right? But enough time has passed, you guys, whereas I can change the name of this channel again to Best of Trial Watch with Demetra. See what I'm saying? I had to wait because I had to wait however many days before I can change it. Now I think I can change it. And I feel like once I have in the title Best of Trial, then I can have more allowance with how we get bored and be moving it right along. Okay. So just to give y'all a little thought into my mind and everything. Y'all know we're going and growing over here. We're doing excellent. I'm excited. But I'm going to go ahead and let you guys go. Court is dismissed for the weekend. Everybody enjoy themselves. And you guys will definitely be seeing me on the other side. Look. Wait, Lady Steph, I have not said that in a long time. Y'all have I have become way calmer. I used to definitely say, wait a minute, this is a dictatorship, not a democracy. I don't even think I've said that in 2024. I am just growing and going. Bye, y'all. Have an excellent weekend. I shall see it to y'all later. Went to say, well, can you switch it to night court so I can fall asleep or take a couple of naps? Hell, I can't go to sleep when I'm working. Switch over what? Oh, switch over to I got you. We'll talk about it. All right, y'all. I get what you're saying. We might throw that in at nighttime. All right. Bye, y'all.
Thanks for watching. Do not forget click the subscribe button and hit the bell icon. Like, comment and share. See you next time.